Claymore House, Baby Farming and the Arrangement That Failed to Remain Invisible. Written by Alana Sanchez, narrated by Vivienne. Copyright 2026 Alana Sanchez. All rights reserved. No part of this book may be reproduced, edited, copied, altered, printed, shared, unauthorized storage on electronic devices, or distributed without the written permission of the author. Author's note. This book is written as nonfiction narrative and is restricted to what can be supported by the historical record. Its foundation is contemporary documentation, court proceedings, inquest material, police testimony where preserved, and press reporting from the period. Later secondary accounts are treated only as pointers back toward primary evidence, not as authorities in themselves. Where sources conflict, the conflict is not resolved by preference or drama. It is left as conflict. The style of this book reflects the limits of what survives. Much of the harm associated with baby farming did not produce complete documentation. Many infants were never securely recorded as living. Many mothers avoided record deliberately, because discretion was necessary to preserve employment, housing, and family standing. These absences are not merely gaps in knowledge. They are part of the conditions that made the trade possible, and they are treated as such. For that reason, this narrative avoids speculation. It does not assign motive where motive is not stated in evidence. It does not invent private conversations, interior thoughts, or scenes that cannot be corroborated. It does not fill missing sequences with imagined continuity. Where certainty ends, the account stops. Where probability can be described, it is described as probability, not as fact. Language in contemporary sources is retained in meaning but not always in phrasing. Victorian reporting often relied on euphemism, moral judgment, and class-coded description. Where those features obscure the sequence of events, they have been translated into clearer modern prose without changing the underlying claim. Original terms are used where they carry legal or historical specificity, and where they are necessary to understand how the arrangement was presented at the time. The intention throughout is precision rather than completeness. This case cannot provide a full accounting of every infant who died, nor can it restore the names that were never recorded. What it can do is show, with documentary support, how one arrangement operated, how it became visible, and how the law responded once it could attach harm to provable chains of responsibility. Any errors in interpretation are mine. Where possible, the reader is given enough structure, names, dates, and institutional processes, to locate the narrative in the record that produced it. The story is not offered as definitive beyond those boundaries. It is offered as faithful within them. Preface. This book is concerned with a crime that did not announce itself as one. At the end of the 19th century, the deaths of infants, particularly those born outside marriage, were common enough to be unremarkable. Medical oversight was inconsistent. Record-keeping was incomplete. Responsibility for children could be transferred informally, and often was. In this environment, harm did not require secrecy so much as alignment with expectation. The case examined here is known primarily through its conclusion, the conviction and execution of Amelia Sach and Annie Walters in 1903. Contemporary reporting framed the outcome as resolution. 2 women were identified, tried, and punished. The matter was considered closed. What follows does not attempt to reopen that verdict. It does not seek to rehabilitate the accused, nor to sensationalize the deaths attributed to them. It proceeds from the surviving record, court transcripts, inquest findings, police testimony, press accounts, and the administrative gaps between them. Where evidence exists, it is stated. Where it does not, the narrative stops. The focus of this book is not only what occurred, but how it was able to occur repeatedly, in plain sight, without immediate interruption. The arrangement that enabled these deaths relied on no single deception. It required only that each participant perform their expected role, and that no one ask questions beyond the limits of propriety. Women arrived seeking discretion. Fees were paid. Children were removed. Outcomes were assumed rather than verified. This was not an isolated practice, nor was it unique to one address. Similar arrangements operated across London and other industrial cities, varying in scale and method but united by the same conditions: social pressure, economic vulnerability, and minimal oversight. The term later applied to these practices, baby farming, was broad, imprecise, and often retrospective. It encompassed both legitimate care and lethal neglect, sometimes within the same household. This book does not attempt to quantify the full extent of that practice. It cannot. Many infants passed through informal systems without ever entering official record. Their lives were not documented, their deaths were absorbed into statistics. Instead, this account begins at the point where the system failed to remain invisible. The exposure of Sach and Walters was not the result of a sudden moral awakening or a comprehensive reform. It occurred because repetition created pattern, and pattern drew attention. Once that attention was applied, the structure of the arrangement became visible enough to prosecute. The chapters that follow trace that process, the environment that normalized the exchange, the investigation that disrupted it, and the trial that rendered it legible to the law. The wider context is addressed only insofar as it clarifies how ordinary such arrangements were, and how narrow the margin was between tolerated practice and criminal charge. No attempt is made here to restore names to every victim, or to impose meaning where none survives. The historical record does not permit that reconstruction. What it does permit is a clear view of how respectability, discretion, and indifference intersected, and what happened when they no longer aligned. Chapter 1: A Respectable Arrangement. In late Victorian London, respectability was measured by what could be seen. A house remained reputable if nothing disturbed the street. A business remained acceptable if it spoke in the correct terms. A difficulty was considered resolved once it ceased to be visible. Claymore House operated inside this logic. It stood in East Finchley, in a district that was neither impoverished nor fashionable. The neighborhood was residential, orderly, and growing, home to clerks, tradespeople, and families who valued privacy and routine. The house itself did not invite attention. It was not concealed. It did not proclaim indulgence. Its declared purpose was plain enough to reassure, and restrained enough to discourage questions. Women arrived there one at a time. They carried small bags. Some were accompanied to the door, some were not. The reasons that brought them were rarely spoken aloud, even between those who shared the same corridor. Pregnancy outside marriage was not simply a private event. It carried consequences that reached into employment, housing, and family support. In the absence of practical alternatives, decisions were often made quickly, under pressure, and without any reliable way to confirm what would follow. Amelia Sach understood those circumstances. As a trained midwife, she occupied a position that was difficult to challenge. A woman who claimed medical skill, whether formally recognized or not, was granted a measure of authority, particularly by those who had reason to avoid formal systems. Sach's advertisements were carefully moderated. They offered comfort, privacy, and experience. They presented competence without emphasis and discretion without detail. The women who answered them were not buying luxury. They were buying concealment. The arrangement, presented as such, was uncomplicated. A fee covered lodging and delivery. A further sum, described as a present for those who would care for the child, secured adoption. There were no written contracts. There was no follow-up. In an era before regulated placement and standardized oversight, the lack of paperwork did not immediately mark an agreement as suspicious. Informality was common. Silence was expected. What mattered was that the child would no longer be the mother's responsibility. Sach's involvement ended at that point. Once payment had been made and the mother departed, the infant ceased to be a person in the eyes of the transaction. It became something to be transferred, counted, and removed. The women who left Claymore House did not witness what came next. They were not expected to return. They were discouraged from asking questions, and most did not. Annie Walters entered at this stage. Unlike Sach, Walters did not trade on professional authority. She moved through the city without announcing herself, and without needing to. When she carried infants, they were bundled and indistinct, easily mistaken for ordinary parcels. Public transport required no explanation. A woman in possession of a wrapped child was not routinely challenged. Proof of guardianship was not demanded. The city assumed legitimacy in ordinary movement. The deaths that followed were not arranged for display. Chlorodyne was widely sold and commonly used. It was marketed as a remedy, stocked as a household medicine, and obtained without difficulty. Its effects on infants were known to medical professionals, but the substance was not controlled in a way that prevented misuse. Given in sufficient quantity, it suppressed breathing until death occurred quietly. In other instances, evidence suggested infants had not been fed. Whether this reflected intention, neglect, or circumstance varied from case to case, but the result did not. Death was not always immediate. It was, however, predictable. The bodies were disposed of according to opportunity rather than ceremony: rubbish tips, waterways, unmarked ground, where discovery, if it occurred at all, did not reliably produce names. The endurance of the operation depended less on concealment than on expectation. Infant mortality was common. Illegitimate infants were especially vulnerable. When bodies were recovered without identification, investigation was often limited. There was no centralized mechanism capable of tracking children who had never been formally recorded as living. Absence could not be measured where presence had never been registered. For years, this absence of oversight allowed the same arrangement to continue. Its collapse was not the consequence of a single act of diligence, but of repetition. Walters's decision to keep infants for short periods within her own lodgings created a visibility the arrangement had previously avoided. A child living, even briefly, under the same roof as a police officer's household was no longer anonymous. One infant death could be explained away. A second strained credibility. A pattern formed where a coincidence had been claimed. Once that pattern became visible, events did not linger. Walters's arrest disrupted the division of labor that had shielded Sach. When Walters was questioned, her movements and associations became traceable. Witnesses placed her at Claymore House. Links that had relied on discretion now had to be accounted for. Searches revealed quantities of baby clothing and infant items that could not be reconciled with legitimate practice. Each garment implied a transaction. Each bundle suggested an outcome that could not be produced. The investigation narrowed by necessity. The law did not require every death to be proven to expose the system behind them. One murder established beyond doubt was sufficient. The infant entrusted by Ada Galli provided that clarity. Payment could be demonstrated through her account. Medical evidence could establish cause of death. The association between Walters and Sach could be traced through visits and arrangements. Responsibility could be assigned in a form the court would accept. The trial that followed did not attempt to enumerate every victim. It did not need to. The structure was plain enough. Money had been taken. Children had been removed. Death had followed with a regularity that made intent inseparable from outcome. When verdicts were delivered, they carried both judgment and relief. Individuals were named, prosecuted, and punished, and in being named they drew the weight of the crime onto themselves. The wider conditions that had made the arrangement possible receded once more into the background, less examined than bypassed. The executions concluded the case in legal terms. They did not resolve what remained beneath it: how many similar arrangements had operated elsewhere, under different names, with the same reliance on discretion and the same absence of verification. The story begins here not because this was the first act, but because it was the first moment at which the arrangement could no longer remain invisible. Chapter 2. The pattern becomes visible. The arrangement endured because it produced no disturbance. Women arrived quietly and left quietly. Infants were removed without ceremony. The city absorbed absence easily, particularly when absence came from those already on the margins of public concern. The system did not depend on a single act of deception. It depended on the ordinary ease with which a child could pass through London without leaving a trace that anyone was obliged to follow. What ended it was not an unexpected discovery, but an accumulation. Walters's decision to keep infants in her own rooms changed the conditions of the work. A child moved directly from Claymore House to an unknown destination remained unexamined. A child carried repeatedly into a single lodging, visible to neighbors, became part of the domestic landscape. The infants did not belong there in any recognized way. They appeared, lingered briefly, and then disappeared. At first, disappearance could still be explained. A woman could claim that a baby had been taken back by its mother. She could speak of fostering arrangements without naming the fosterer. She could rely on the fact that poor families did not demand documentation, and that most outsiders did not consider it their business to ask. Lodgers came and went. Children were moved between houses. London was full of temporary lives. But the tolerable explanation changed once death entered the immediate space. An infant dying in a private dwelling was not automatically a police matter. It was, however, an administrative problem. A doctor might be required. A cause might be recorded. A burial might be arranged. When the same sequence repeated, an infant brought in, an infant taken ill, an infant removed again. Those ordinary processes no longer produce the appearance of ordinary life. The first concerns were not framed as murder. They were framed as irregularity. Neighbors notice what is repeated. Landladies notice what alters the rhythm of a house. In lodgings, domestic life is never fully private. The thin walls and shared passages do not produce intimacy, but they do produce knowledge. An infant's crying carries. A sudden silence is also heard. When questions were raised, they were raised as practical matters. Who was responsible for the child? Why the child was present? Why the child was no longer present? Whether a doctor had been called? Whether a burial had been arranged? These questions could be postponed once. They could not be postponed indefinitely. The point at which police attention became unavoidable was not a single dramatic scene. It was the moment when repetition made evasion impossible. Once Walters was spoken to formally, the arrangement that had protected her began to collapse under its own structure. A system that relies on informal transfers cannot easily defend itself under questioning, because its strength is the absence of record. The same absence becomes weakness the moment record is demanded. Statements were taken. Addresses were noted. Names were asked for and sometimes refused. The language of nursing and adoption was used as it had always been used, to describe a transfer without describing its outcome. But under scrutiny, those terms required detail. Who had paid? Who had delivered the baby? Who had taken it away? Where it had gone? Who had seen it afterwards? The answers, when provided at all, did not resolve cleanly. They created connections. Walters could not account for the infants as living children placed into known homes. She could not produce adoptive parents. She could not provide addresses that could be visited and verified. What remained was her own movement through the city, her presence in the streets, her visits to certain houses, her possession of items associated with infant care, and the short span between arrival and death. From that point, the investigation did not widen so much as it drew backwards. Walters had not recruited the mothers. She had not run the advertisements. She was not the first point of contact. She operated at the stage where the child had already been transferred out of the mother's hands. That meant there had to be an earlier stage, a place where the transaction began, and someone who presented it as safe. Claymore House became visible in the investigation in the way such places often do, through repetition of address in accounts that were not meant to align. A woman describing where she had delivered, a neighbor describing where Walters went, a witness describing where a baby was collected, separate statements that converged on the same location. Once the address was fixed, the appearance of respectability could not prevent scrutiny. It could only delay it. Claymore House did not declare itself a crime scene. It had never needed to. Under the arrangement, it functioned as a threshold, a place where a woman could disappear for a short period, give birth, and return without the child. The house existed to provide a plausible narrative for the outside world. It offered privacy in exchange for money, and the silence that followed was part of the fee. Searches and visits altered that balance. The evidence that drew attention at Claymore House was not, at first, dramatic. It was ordinary in type and troubling in quantity. Infant clothing, baby linen, feeding bottles, parcels prepared for children not present. Items that might be explained if a household contained a baby, or if a midwife were properly engaged in nursing work, became harder to explain when no corresponding children could be named. Each object implied a child who had passed through and left no trace. In a legitimate arrangement, an infant's presence produces a chain: a mother, a birth, a living child, a carer, a home, a registration, a continued existence. In this case, objects stood alone. They were remnants without continuation. The quantity mattered because it suggested scale. The lack of continuity mattered because it suggested outcome. The investigation moved as investigations of this period often did, in fragments, with emphasis placed on what could be proven rather than what could be suspected. It was not necessary to establish every death. It was necessary to establish one death as murder and then attach it to an identifiable chain of responsibility. That chain required three things the courts would accept: a payment, a transfer, and a cause of death. The case that provided that chain was the infant entrusted by Ada Galli. Galli's testimony mattered because it turned a private arrangement into a documented sequence. It fixed the transaction in time. It described the terms under which money was paid. It identified the people involved. It established that the child had been handed over under the promise of care and adoption, and that the child did not return. Her account was not important because it was unique. It was important because it could be tested. Payment could be corroborated. Movements could be checked. Witnesses could confirm the visits and the handover. Medical evidence could be applied to the infant's death in a way that moved beyond suspicion. A court could understand the chain because it resembled a contract, even if no contract existed. Once the chain was constructed, the broader system began to appear not as a series of accidents, but as a method. The medical evidence did not need to be elaborate to be decisive. Chlorodyne was a known substance, sold openly as a remedy. Its use in households was common enough to be unremarkable. Its effect in infant doses was not mysterious. The question was not whether it could kill, but whether it had been given in a quantity that could only be intentional. Where starvation was suspected, it carried a different problem. Neglect can be argued. Intention is harder to prove. Chlorodyne allowed the prosecution to present death not as misfortune but as an act, a substance administered, a body suppressed, a life ended in a manner consistent with deliberate use. The inquest process, where it occurred, provided the necessary bridge between domestic suspicion and legal certainty. A coroner's inquiry could place death into an official record. A doctor's statement could fix cause. A burial that should have required paperwork could be shown to have proceeded without it. Each of those details moved the infant from private disappearance into public accountability. The structure of the case was built on that movement. By the time the matter reached court, the story did not need to be told in full to be understood. It needed to be told in a form the law could manage. That meant narrowing the narrative to what could be proven beyond doubt and resisting the pull of what could be inferred. The prosecution did not need to name every child who had died. It needed to demonstrate that the arrangement itself produced death as routine, and that those who profited from it knew what they were doing. That knowledge was argued through role. Sach was presented as the first stage, the woman who received pregnant women, took fees, delivered infants, and passed those infants on under the promise of adoption. Walters was presented as the second stage, the woman who took possession of the infants and removed them from visibility. Together, they formed a division of labor that made the work efficient and, for a time, difficult to trace. The court did not require that the two women commit the same acts. It required that they be responsible for the outcome. The defense, where it had room to operate, relied on the same ambiguities that had protected the arrangement outside the courtroom. Informal adoption was common. Infant illness was common. Poor record-keeping was common. A midwife could plausibly claim she believed she was placing children into care. A woman who carried infants could plausibly claim she was transporting them to foster homes. The city's tolerances could be used as an argument for innocence. But the tolerances had limits once death was pinned to a chain of custody. One infant, properly attached to witnesses, payments, and medical cause, could not be explained away as general misfortune. Once that infant was established as murdered, the rest of the arrangement changed meaning. Clothing became evidence. Visits became evidence. Money became evidence. Silence became evidence. The courtroom did what the streets could not. It demanded a coherent account. In that setting, respectability did not function as protection. It functioned as a contrast. The calm presentation of the arrangement, discretion, comfort, legitimacy, was set against the outcome that followed repeatedly, infants removed and never seen again. The verdicts that followed were not framed as complicated. The case was made legible by the way it was narrowed. It did not attempt to describe every death. It described enough to show method, and enough to attach method to named individuals. It presented the arrangement not as a set of isolated failures, but as a system in which death was predictable and profitable. When judgment was delivered, it brought closure in the form the law prefers: a named offender, a named crime, a defined outcome. Outside the courtroom, the conditions that had permitted the arrangement remained largely intact. Women would still face the same pressures. The need for discretion would still exist. Informal transfers would continue, because they were built into a society that punished visible need more reliably than it punished private harm. The case was exceptional only in its exposure. What became visible in court was not a single act, but a mechanism, a respectable threshold, an invisible transfer, and the quiet removal of what had become inconvenient. The public conclusion placed responsibility on two individuals, and in doing so it allowed the larger structure to recede again into the ordinary workings of the city. The investigation had ended an arrangement. It had not ended the conditions that produced it. And what could not be measured, how many children had passed through the same chain without record, without inquiry, and without name, remained outside the frame, where it had always been. Chapter 3. The Trade in Infants. The arrangement exposed in the Sach and Walters case was not unusual because it involved money. It was unusual only because it was interrupted. In late 19th century London, the transfer of infants from one household to another was a familiar practice. It occurred through kinship, employment, crisis, and necessity. It also occurred through commerce. The boundary between informal care and paid placement was not fixed by clear rules. It shifted according to circumstance, and it was often obscured by language designed to make the exchange appear respectable. The term later used to gather these practices, baby farming, did not describe a single method. It described a market. At one end were women who took in infants for nursing and board, sometimes for short periods, sometimes long. Many of these arrangements were not criminal. They were substitutes for family support in a city where poverty, illness, and domestic instability were common. Payments were often small and irregular. The infants who survived did so largely because care, however limited, continued. At the other end were arrangements designed to end the burden quickly. One payment, no return, no questions. When an infant was exchanged under those terms, survival depended on the intentions and capacity of whoever received it. A child taken for a lump sum was, in economic terms, a completed transaction. The incentive to continue spending time and resources on that child was limited, and in some cases absent altogether. Between these extremes were many households that moved in and out of legitimacy. The same woman might provide genuine care for one infant and neglect another. The same address might function as a nursery one month and a place of disposal the next. When oversight was minimal, a practice did not need to be consistently murderous to be lethal. It needed only to place infants into settings where death could occur without consequence. London did not lack mechanisms of authority. It lacked mechanisms of verification. Infant life was difficult to track. Birth registration existed, but it did not guarantee that a child remained visible. Many births were recorded late. Some were not recorded at all. A child might be born in one parish and die in another, under a different name, without ever being formally linked to the mother who delivered it. A nurse might claim an infant belonged to a relative. A midwife might claim she had merely assisted. Each link in the chain relied on testimony rather than documentation. The social conditions surrounding illegitimacy intensified that invisibility. For an unmarried woman, a pregnancy could mean dismissal, eviction, and permanent loss of reputation. Those consequences were not hypothetical. They were enforced through employment contracts, landlord discretion, and family refusal. Privacy was not a preference, it was often the only way to remain housed and employed. The simplest form of privacy was distance, leaving a neighborhood to give birth elsewhere, and returning without a child. That need created demand. The market did not present itself as a market. It presented itself as remedy. Advertisements offered respectable homes, kind nurses, and private adoption. The language was designed to imply safety without describing process. Respectability became a product, a promise that no disturbance would reach the mother's ordinary life. The absence of disturbance was also the system's protection. A legitimate adoption required time, identity, and paperwork. The baby farming market offered speed. It offered discretion. It offered the removal of responsibility. It often did so without names, without contracts, and without any expectation that the mother would ever see the child again. Where money was paid weekly, a child remained economically alive. The carer was paid only if the child continued to exist. Where money was paid as a single lump sum, the child became economically irrelevant the moment it arrived. That shift in payment structure altered the risk. It did not guarantee death, but it created a condition in which death became an acceptable outcome rather than a failure. The means by which infants died were not always dramatic. They did not need to be. Neglect could kill without leaving marks. Diarrhea, malnutrition, dehydration, exposure, and infection were common causes of infant death even in ordinary households. In an overcrowded lodging where feeding was inconsistent and sanitation poor, death could be explained as misfortune. Where infants were deliberately sedated, death could be made quieter still. Drugs sold openly as household remedies were capable of suppressing appetite and breathing. Their use required no specialist access, only willingness. The law struggled to meet this reality because it was built to address individual acts rather than markets. A murder charge required a provable victim, a definable cause, and a chain-linking act to accused. Baby farming dispersed responsibility. It substituted a series of informal steps: advertisement, payment, handover, removal, for a single identifiable event. Even when an infant body was recovered, the first obstacle was identity. Without a name, the death remained a general tragedy rather than a prosecutable offense. The administrative systems that might have made identity stable did not function as a net. There was no centralized register capable of signaling that a child recorded at birth had vanished without explanation. There was no reliable mechanism to connect a found body to a specific home, a specific payment, a specific handover. Jurisdiction was fragmented across parishes and boroughs. Responsibility could be displaced by crossing a street. In that environment, the practice could persist not because it was expertly concealed, but because it did not need to be traced to survive. It needed only to remain ordinary enough to be ignored. What made the Sach and Walters case legible to the law was that it combined two things baby farming usually avoided: repetition in one place, and traceable transaction. The women who came to Claymore House were purchasing an ending. Sach offered that ending in respectable form. Walters provided the physical removal that made it permanent. Their roles were distinct enough to reduce exposure, but connected enough that once one part of the mechanism became visible, the rest could be followed. The case also arrived at a moment when public anxiety about infant welfare had already begun to sharpen. The language surrounding baby farming had shifted in the preceding years from tolerance to suspicion. Newspapers increasingly framed such arrangements as moral danger and social threat. Reformers argued for oversight not only because infants died, but because their deaths suggested an economy operating beyond respectable control. This did not mean the city suddenly became vigilant. It meant that when a pattern appeared, it could be interpreted as criminal rather than merely unfortunate. In many cases, baby farming surfaced only after bodies were discovered. The Sach and Walters arrangement surfaced because living infants were briefly visible in a domestic setting where they did not belong, and because their disappearance occurred too close to ordinary witnesses to remain unremarked. Once suspicion formed, the market's usual protections, silence, informality, distance, became liabilities. The same lack of paperwork that had reassured mothers now prevented the accused from producing plausible outcomes. The wider practice remained largely intact after the executions, because it was sustained by conditions rather than by the particular individuals who had been removed. Women would continue to seek discretion. Poverty would continue to press infants into precarious care. The law would continue to require certainty in a system built on absence. The market would adapt as markets do, shifting addresses and names and methods while preserving the same exchange: money paid for the removal of a problem. The Sach and Walters case therefore sits within baby farming less as an exception than as a rare moment of visibility. It shows what was usually hidden in plain form: a respectable threshold, a transferred responsibility, and a child who could be made to vanish without immediate consequence. It shows how the city's tolerance for disappearance created a space in which death could become routine. It also shows, by contrast, what was required to interrupt that routine. Not universal reform. Not perfect oversight. Only enough repetition in the wrong place, witnessed by the wrong people, to turn a private arrangement into a public pattern. And once the pattern was public, it could be named. Chapter 4: What the Court Could Hold. When the case reached the courtroom, it had to be translated. The investigation had produced a picture of routine: women arriving, money changing hands, infants removed, infants not returning. It had produced objects that suggested volume, witnesses who suggested repetition, and a chain of contact that ran from Claymore House to Walters's rooms. Outside court, those elements formed a mechanism. Inside court, they had to be reduced to something narrower: a charge the law recognized, a victim the law could name, and a sequence of actions that could be proved beyond doubt. The court was not built to try a system. It was built to try a person. That constraint shaped everything that followed. The prosecution did not present the full scope of what was suspected. It presented what could be anchored. A single infant, attached to a mother, a payment, a handover, and an identifiable death, could carry the rest of the structure with it. The rest did not need to be proven individually to be understood. It needed only to be rendered believable. This was why the infant entrusted by Ada Galli mattered in legal terms. Her account did not offer a general truth about the city. It offered a specific transaction, a pregnancy managed in private, a delivery arranged, money paid, and a child removed under the promise of care. In a case defined by disappearance, specificity was the most valuable form of evidence. The court could not work with absence unless absence had edges. Galli's testimony fixed those edges. It gave the prosecution a beginning that was not speculative, a mother who could name the people she dealt with, and who could describe the terms offered to her. The language of those terms, discretion, adoption, good homes, was not unusual enough to be incriminating on its own. Its significance lay in what followed it, the child's removal from her knowledge, and the impossibility of producing the child as living. From that point, the prosecution did what such cases required. It stacked ordinary facts until they became extraordinary in combination. Witnesses were used to confirm movement, the visits to Claymore House, the handover, the carrying of infants through the city, the presence of infants in Walters's lodgings, the timing of their disappearance. Some testimony did not need to prove murder. It needed only to prove custody. Once custody was established, medical evidence could do the rest. The medical evidence was presented in the plainest form available to the period. The question was not whether infants died easily. Everyone in the court understood that they did. The question was whether this infant's death could be explained as natural. Chlorodyne made that question easier to frame. It was a substance that sat uneasily between medicine and poison. It was available, familiar, and commonly used. That familiarity mattered. A jury could understand how it might be obtained without difficulty, and how it might be administered without leaving the kind of marks the public imagined in a violent death. The prosecution did not need the drama of injury. It needed the logic of means. In a case where neglect could be defended as poverty, Chlorodyne suggested action. Where starvation might be argued as incompetence or hardship, sedation implied deliberate suppression. A substance given in a quantity sufficient to stop breathing did not resemble an accident, particularly when the substance had no legitimate reason to be given to an infant at that dose. The court did not require modern toxicology to grasp this. It required a doctor willing to say, in language the jury could understand, that the death was consistent with drugging rather than illness. This did not mean the evidence was perfect. It meant it was usable. The defense, such as it could be mounted, depended on the very conditions that had allowed the practice to exist. Informal fostering was common. Infants were moved between homes. Records were inconsistent. A midwife could claim she believed she was arranging legitimate care. A woman who carried infants could claim she was transporting them to carers. If the city tolerated these explanations, the courtroom could be asked to tolerate them too. But toleration weakens when repetition becomes visible. The prosecution's advantage lay in pattern, even though the charge could not be pattern. It lay in the accumulation of infant-related items that could not be reconciled with any legitimate household use. It lay in the inability to name adoptive parents. It lay in the repeated appearance of infants who were briefly present and then unaccounted for. Each individual point might have been explained away. Together, they created a context in which the promised good home became implausible. The court did not need to count victims to recognize method. It needed only to recognize that the method, when described honestly, had no innocent endpoint. This was the moment when the euphemisms that had protected the arrangement became a liability. Terms like adoption and nursing were acceptable so long as no one demanded a destination. In court, destination was precisely what was demanded. Where did the infant go? Who took it? Who kept it? What name did it live under? What address did it sleep at? Who paid for its continued care? The inability to answer these questions did not prove murder on its own. It did, however, strip away the respectable explanation and leave only the transaction. Money had been taken. A child had been removed. A body had followed. The courtroom also imposed another narrowing. It required the jury to sort responsibility between two women whose roles were linked but not identical. The prosecution framed this as division of labor. Sach was positioned at the point of entry. She received pregnant women, took fees, conducted deliveries, and offered placement. Walters was positioned at the point of disappearance. She took possession of the infants and carried them away from the final witness who might have insisted on seeing them again. One did not need to be present at the moment of death to be held responsible for it, if the arrangement was understood as intentional. That was the logic the prosecution relied upon. It treated the infant's death not as a single event but as the predictable outcome of the transfer itself. The defense could attempt to fracture that logic. It could argue that Sach's responsibility ended at delivery, that she believed she was placing infants into care, that Walters acted independently afterwards. It could argue that Walters's actions were those of a nurse, not a killer. It could argue that infants died in the ordinary course of fragile life, and that coincidence was being mistaken for design. But coincidence struggles when it repeats under one roof. In the end, the court returned to what it could hold: one child, one payment, one chain of custody, one cause of death. That spine supported the rest. Around it, the objects and witnesses and repeated movements did not need to be charged as separate murders. They needed only to show that the one proven death was not an isolated misfortune, but part of a practice. When verdicts were delivered, they served a dual purpose. They punished individuals, and they provided a conclusion that the law could present as closure. The arrangement had relied on the city's willingness to treat certain disappearances as private. The courtroom made the disappearance public, translated it into a narrative of guilt, and assigned it to named people. Once that assignment was complete, the wider conditions that had made the arrangement possible became easier to ignore again. The case ended in legal terms because the law had reached the limit of what it could prove. What remained beyond that limit, the number of infants whose names were never recorded, the transactions that left no witness willing to speak, the homes where the same practice continued in quieter forms, did not enter the judgment. It remained outside the court's frame, where most infant deaths had always been. And yet the mechanism had been shown plainly enough. Respectable language, private payment, a vanished child. In court, that sequence became something the city could not dismiss as merely unfortunate. It became a crime that could be named, tried, and concluded, without ever fully revealing the scale of what it had interrupted. Chapter 5. After the verdict. The executions produced a conclusion that was decisive but limited. In the immediate aftermath of the trial, the case was treated as resolved. Newspapers reported the sentences as the removal of an aberration. 2 women had been identified, judged, and punished. The narrative settled into a familiar shape: an exposed evil, a corrective response, and a restored sense of order. The city moved on. What did not follow was a comprehensive reckoning. There was no inventory of children unaccounted for beyond those directly named in evidence. There was no systematic effort to trace every woman who had passed through Claymore House, nor to reconstruct the full number of infants transferred under the same terms. The investigation had not been designed to measure scale. It had been designed to secure conviction. Once that goal was met, the machinery that had been assembled for the case was dismantled. This was not an oversight unique to this trial. It reflected the limits of institutional concern. The law responded to demonstrable crimes, not to structural conditions. It addressed outcomes that could be named and proven, not patterns that could be inferred. The Sach and Walters case satisfied the requirement for accountability by identifying responsible individuals. Having done so, it allowed the broader context to remain largely unexamined. Public discussion followed a similar course. Editorial commentary framed the executions as a warning. Baby farming was denounced in general terms, often with language that suggested moral decay rather than administrative failure. The focus remained on the character of those involved, not on the systems that had enabled them to operate. Condemnation substituted for analysis. Outrage displaced inquiry. This emphasis was reassuring. It suggested that the danger had been contained. The conditions that had created the market, however, did not change quickly. Unmarried women continued to face dismissal and exclusion. Poverty continued to limit choices. The need for discretion did not disappear with the removal of 2 names from the register. Informal transfers of infants continued because formal alternatives remained inadequate or inaccessible. Reform, where it occurred, was partial and uneven. There were renewed calls for regulation of infant care and fostering arrangements. Some local authorities increased scrutiny of known nursing homes. Inquests were encouraged to ask more detailed questions when infants died outside family care. Registration procedures were discussed and, in some cases, tightened. These measures improved visibility at the margins. They did not eliminate the practice. One reason was practical. Oversight required resources, coordination, and sustained interest. It required the state to follow children whose existence had previously been treated as provisional. That level of attention was difficult to maintain once the immediate shock of the case faded. Another reason was social. Many of the arrangements grouped under the term baby farming occupied a gray zone that reformers themselves relied upon. Families used informal nursing. Employers tolerated temporary disappearances without documentation. Communities preferred solutions that kept disruption out of sight. Regulation threatened to expose not only criminal practice, but ordinary compromise. The case therefore entered public memory in a narrowed form. It became an example of extreme abuse rather than a demonstration of systemic risk. Sach and Walters were remembered as exceptions rather than as participants in a broader economy. The phrase baby farmer acquired a moral weight that allowed other, similar arrangements to distance themselves from the label without necessarily changing their substance. The legal record reinforced this narrowing. Once executions were carried out, there was little incentive to reopen the file. Appeals were exhausted. The evidence was archived. The case ceased to generate new documentation. What remained were fragments, trial transcripts, newspaper summaries, inquest notes, and references in reform literature. Each preserved part of the story while omitting others. The victims, as individuals, receded almost entirely. Infants who could not be named did not persist in the record. Mothers who had paid for discretion did not come forward after the trial to demand answers. Many had already rebuilt their lives around the assumption that the child was gone. Reopening that assumption carried risks that few were willing to take. Silence continued, now reinforced by finality. In this way, the verdicts achieved a form of closure that was functional rather than complete. They established that infants had been killed deliberately. They demonstrated that informal arrangements could be criminal. They punished those found responsible. They did not reconstruct the full extent of harm, nor did they fully dismantle the conditions that had allowed it to occur. The city absorbed the case as it absorbed so much else, by isolating it. What remained unresolved was not a question of guilt, but of repetition. The same pressures persisted. The same euphemisms remained available. The same gaps in oversight continued to exist, albeit under greater suspicion. The arrangement exposed at Claymore House was no longer invisible, but neither was it singular. The case had drawn a boundary, not erased a practice. Its legacy lay less in what it changed than in what it revealed, that infant life could be negotiated, transferred, and extinguished within ordinary social systems, and that those systems could resume their function once a disruption had been contained. The story does not end with the verdict because the conditions it exposed did not end there. What follows is not a catalogue of reform, nor a claim of progress measured against modern standards. It is an examination of how memory settles around such cases, what is preserved, what is simplified, and what is allowed to disappear again once the immediate need for explanation has passed. The executions closed the case. They did not close the space in which it had occurred. Chapter 6: What the record preserved. After the executions, the case ceased to generate new facts. There were no further searches that would add to the inventory of objects. No new witnesses were compelled to speak. No new bodies, newly identified, were brought into the courtroom narrative. The state had done what it required of itself. It had produced a charge, secured a conviction, and carried out punishment. The remainder, everything not essential to that sequence, was permitted to fall back into ordinary administrative silence. What survives of the case survives in fragments, and those fragments were not created for the same purpose. Some were produced to persuade, newspaper accounts written to hold attention, selecting detail for effect and compressing complexity into legible moral story. Some were produced to record, inquest findings, depositions, summaries of testimony, lists of exhibits. Some were produced to conclude, sentencing remarks and official notices that emphasized closure over breadth. Together, they form an uneven archive, precise in places where the law required precision, thin where the law did not insist. The result is that the case, as it can be reconstructed, has a defined spine and indistinct edges. The spine is clear because it had to be. It contains the names the court could use, the infant the prosecution could attach to a traceable chain, the payments that could be described without ambiguity, and the medical conclusions the jury could be asked to accept. These elements were not preserved because they were the most important in human terms. They were preserved because they were the most useful in legal terms. Beyond that spine, the record becomes less certain. Many of the women who entered Claymore House did so to avoid being recorded. That was the value they were purchasing. Their movements were designed to leave as little imprint as possible, arriving alone, leaving alone, returning to ordinary life without the child. Even where names were taken at the time, there was often no mechanism to match those names to future inquiry, and no incentive for the women themselves to return to a process that could expose them. If an infant's life never entered official record in a stable way, its disappearance could not be measured as disappearance. A child not securely registered as living could die without generating the kind of absence an institution knows how to count. This was the most effective protection the arrangement possessed, and it remained effective even after exposure. A body discovered in a waterway or on waste ground might prompt an inquest, but an inquest without identity could only reach conclusions in general terms. The body could be described. The probable cause could be suggested. The verdict might state found dead, death from exposure, or death from suffocation, with varying degrees of confidence. Without a name, the death remained unattached to a life that could be traced backward. Even when the court acknowledged that multiple infants had died, it did not convert that acknowledgement into a list. The trial did not operate as an accounting exercise. It did not aim to restore individual identity to every child whose clothing or bottle remained in evidence. Its purpose was to determine culpability, and culpability could be established without enumeration. The law required proof of murder beyond reasonable doubt. It did not require a census of victims. That narrowing had consequences. Once the verdicts were delivered, the archive hardened around the case as prosecuted, not the case as lived. The infants not selected as legal anchors receded almost immediately. Their presence remained as implication, in the quantity of objects, in the pattern of witness remarks, in the repeated language of adoption and nursing, but implication is not the same as documentation. It does not preserve names. It does not preserve dates. It does not preserve sequences that can be tested. What the record holds most firmly is the point at which the arrangement intersected with institutions. The moment a doctor was called, a coroner was notified, or a police officer took notice, paper was created. Those papers survive unevenly, but they exist because the system had been touched. Where the arrangement remained within private space, between women, within rooms, carried through streets as a bundle, it generated little that could persist. This is one reason the case appears, even now, simultaneously detailed and incomplete. It is possible to follow the investigative trail because investigators, once engaged, created a trail. It is possible to reconstruct the courtroom narrative because courts preserve narratives. It is harder to reconstruct what preceded that engagement because the arrangement's success depended on keeping the earliest stage outside formal sight. The record can show the point of failure with clarity. It can show the years of functioning only as shadow. Press coverage fills some gaps, but it does so unreliably. Newspapers were not neutral recorders, and they did not pretend to be. They selected and shaped. They repeated details that held public attention and omitted those that did not. They summarized testimony in language that suited readers rather than transcripts. At times they offered information not preserved elsewhere. At other times they introduced distortions, of sequence, of emphasis, of motive, that cannot be verified against primary documentation. This is the problem that remains when a case becomes infamous. Its story is repeated so often that repetition begins to substitute for evidence. Later accounts borrow from earlier accounts. Descriptions harden into fact through circulation rather than corroboration. The more legible narrative becomes the one most frequently told, not the one most securely supported. The case therefore survives in two forms at once, the legal case and the public case. The legal case is narrow, anchored to what could be proven. The public case is broad, anchored to what could be imagined from the proven facts. Between them is a space that appears, on first glance, to be an empty gap. It is not empty. It is populated by lives lived privately, transactions conducted quickly, and decisions made under pressure, events that do not persist on paper because their participants did not want them to. For the victims, this has a final effect. A child who dies nameless remains nameless. A mother who paid for discretion is preserved, if at all, as a witness rather than as a person with a continuing life. The case becomes a framework, a mechanism, a story of how something could operate. The individuals inside it disappear into their roles because roles are what archives preserve most readily. This is the limit of reconstruction. It is possible to show how the arrangement functioned, and how it was interrupted. It is possible to identify the language that made it respectable, and the gaps that made it viable. It is possible to follow the chain where the chain left marks. What is not possible, because the record does not permit it, is to restore a complete list of the infants removed, or to assign certainty where only inference exists. That is not a failure of narrative. It is the condition under which the arrangement was able to operate. And it is the condition that remains, after verdict and execution, as the most enduring trace of the crime, not only the deaths that occurred, but the ease with which those deaths could be absorbed into a city that did not reliably record the existence of the children it was losing. Chapter 7: The House That Remained. Claymore House did not vanish when the case ended. The address had been made public, repeated in print, spoken in court, and fixed in testimony. In legal terms, it became part of the narrative. In the physical city, it remained an ordinary structure on an ordinary street, subject to the same gradual changes that altered all neighborhoods: new tenants, altered interiors, different owners, new paint over old rooms. A crime scene does not always retain the appearance of crime. For the women who had used the house as a threshold, its meaning had already been temporary. They had come to it for privacy and left it behind as quickly as possible. They did not belong to the neighborhood. They did not invest the house with memory. Claymore House was useful precisely because it did not demand attachment. It offered a brief removal from ordinary life, and then released women back into their usual world with minimal trace. That same quality made the house adaptable. A respectable street did not require a moral inventory of every interior. It required quiet. The neighborhood stability was built on the assumption that private life remained private. Even after a case became notorious, the street could return to its routines because routines were what it defended. The scandal was externalized as an event, not absorbed as a permanent condition. Infamy does not automatically change property. The case damaged reputations, not bricks. It produced condemnation, not demolition. The law punished individuals, not locations. Once the machinery of prosecution had done its work, the house could be reabsorbed into ordinary use. In this way, Claymore House illustrated the city's ability to compartmentalize. Public attention had been intense while the trial progressed. The address functioned as shorthand for what had been discovered: a respectable front, a private arrangement, an unseen outcome. But attention is not durable. Newspapers replaced one case with another. Outrage moved on. The moral certainty the public drew from the executions allowed them to treat the danger as concluded. The house remained, but its meaning became negotiable again. For some, it would have remained marked by association, a place to be avoided or spoken of in lowered voice. For most, it would simply have been a building in a growing district, part of the city's expansion, part of its housing stock, part of a street that continued to value order. In a metropolis, even notorious addresses are gradually overwritten by new occupancy and new concerns. What persisted most reliably was not the house itself, but the pattern it had represented. Claymore House had served as a node, a point where secrecy could be purchased, and where responsibility could be transferred. The case revealed that such nodes were not difficult to establish. They required no sophisticated disguise. They required only the right language, a plausible role, and clients motivated to accept an ending without inquiry. Those conditions did not disappear because one address was exposed. If Claymore House could resume its ordinary appearance, so could other houses. If one midwife could offer privacy and adoption with no paperwork, another could do the same. If one system could operate long enough to produce a pattern only visible in retrospect, there was no reason to assume it had been unique. The prosecution had placed the weight of the arrangement onto two women because the law requires that weight to be carried somewhere. The effect of that assignment was not only punishment. It was simplification. It allowed the public to locate the danger in individuals rather than in the normal tolerances that had enabled them. The house benefited from that simplification. Once individuals were removed, the address could be treated as neutral again. The shame attached to those who had used it could remain private. The neighborhood could continue without needing to identify itself as complicit. The city could fold the place back into its fabric without admitting how easily that fabric had held the arrangement in place. In this sense, Claymore House was not exceptional for what occurred inside it. It was exceptional for how briefly it refused to disappear. The case forced the house into visibility because it forced the transaction into visibility. It showed that a respectable exterior could function as part of a lethal mechanism. But it also showed how quickly the city could restore the ordinary status of a place once legal closure had been achieved. The house remained. The street remained. The district continued to grow. What could not be seen again, once court proceedings ended and attention moved away, was the interior logic that had once made the house useful. That logic depended on the same forces that had existed before: the threat of social ruin, the demand for discretion, the willingness of authorities to accept disappearance as private. Those forces were not tied to one address. They were tied to the way the city managed inconvenience. Claymore House had been one location where that management took material form. After the case, it could become simply a house again, its rooms repurposed, its name fading, its function erased from sight. The arrangement that had operated through it required only that this erasure be possible. And it was. Chapter 8. The Women. Who could not return. The women who passed through Claymore House were not the subject of the trial in any meaningful sense. They appeared in the record when they were needed, as witnesses, as sources of payment, as points of transfer. Their lives were otherwise treated as irrelevant, or too private to be examined. The court did not ask what followed them home. It did not measure what it cost to speak, or what it cost not to. It required only the elements that could be made to serve proof. That narrowing reflected the arrangement itself. Women sought Claymore House because they could not afford to be visible. The danger was not the pregnancy alone, but what it would make public. Employment could be lost without appeal. Lodgings could be withdrawn without explanation. Family support could be terminated with a single refusal. In that environment, discretion was not an accessory. It was protection against immediate material harm. This was why the transaction could operate without paperwork. A woman paying to be concealed had little incentive to demand documents that would implicate her. A woman paying for the child to disappear could not safely insist on a trail. The same pressure that brought her to the house also ensured that once she left it, she would not return. When the case surfaced publicly, that pressure did not dissolve. It intensified. A trial that named the practice also exposed those who had resorted to it. Even when witnesses were treated with formal respect in court, their circumstances were legible to anyone reading between lines. The language of the time did not protect them from judgment. It sharpened it. The very fact of appearing in relation to the case could become a second punishment, delivered socially rather than legally. For many women, silence remained the safer option. The record therefore preserves only a fraction of those involved, those who could be located, those who could be compelled, those who were willing to risk recognition. Each testimony that survives implies many more that never occurred. The mothers whose infants were found without identification could not be summoned because they could not be named. The mothers who had paid and disappeared could not easily be traced because the transaction had been designed to leave no forward address. In that sense, the arrangement did not end at the moment of handover. It extended into the mother's continued absence. The trial, by necessity, treated mothers as the beginning of a chain rather than as individuals living under constraint. Their accounts were used to establish payment, to identify names, to confirm dates. Their emotional reality, whatever it may have been, was not admissible evidence. It could not assist the prosecution in proving murder. It could, however, distract. The courtroom required a story that could be managed, and the private complexities of women's lives were not manageable within legal form. As a result, the mothers remain in the archive as partial figures. They are often described in relation to the infant rather than in relation to themselves. They appear as the woman who paid, the woman who delivered, the woman who handed over. Their lives before the pregnancy and after the disappearance are rarely preserved. The case enters their histories as a rupture, but their histories do not enter the case. This is one of the more durable injustices of the record. The arrangement relied on women being isolated. It relied on them arriving alone, deciding quickly, and leaving without support. It relied on the shame attached to illegitimacy to prevent complaint. Those conditions did not become less severe because a case became notorious. In some respects they became more severe, because notoriety turned the private decision into a public category: the woman who had her child adopted away, the woman who used a baby farm. Even when the court was satisfied that a woman had been deceived, society did not always accept deception as mitigation. The case therefore produced two exposures at once. It exposed the operators of the arrangement. It also exposed the women who had been forced into it by circumstance. The difference was that the operators were punished by law, while the women risked punishment by reputation. This distinction shaped who could safely speak. The court asked for certainty where certainty was possible. Yet certainty was often produced through the very vulnerability that made the women cautious. To establish a chain, a witness had to admit the payment, the delivery, and the handover. In doing so, she had to admit the condition she had tried to hide. The law offered no blanket protection against the social consequences of that admission. The record, accordingly, contains gaps that are not simply missing paperwork. They are missing people. Some women could not return because they did not know what had happened and did not discover it. Some could not return because they suspected what had happened and could not risk proving it. Some could not return because to return would require confronting institutions that had already failed them, employers, families, parishes, and officials whose sympathies were not guaranteed. The arrangement did not need their continued silence to operate, but it benefited from it. When the case ended, the women who had spoken did not receive closure in any formal sense. A guilty verdict did not restore the child. An execution did not answer questions of number. It did not provide a mechanism by which a mother could learn, with certainty, what had happened to an infant who had been taken under promise. The court resolved guilt. It did not restore knowledge. For most women, knowledge was never an option the system prioritized. This is why the story, even told carefully, cannot be complete. The mothers were central to the transaction and peripheral to the public narrative. Their silence was not simply a personal choice. It was built into the conditions of the time. It was enforced by material risk, social judgment, and the lack of safe alternatives. The case is remembered as a crime committed against infants. It was. It was also a crime committed in a landscape shaped by the threat of disgrace, where women could be made to pay for invisibility and then required to maintain that invisibility even after the consequences became public. They could not return to claim what had been taken, because returning would make visible what they had been punished for in the first place. And the arrangement had been designed from the beginning to ensure that they did not. Chapter 9, The Language That Made It Possible. The arrangement did not begin with violence. It began with words. What Claymore House offered was not described as the removal of a child. It was described as relief, privacy, a respectable solution. The language was not decorative. It was functional. It allowed a transaction to take place without requiring anyone to name what the transaction was. In late Victorian London, words were often used to smooth the boundary between what was tolerated and what was condemned. A practice did not need to be openly lawful to be openly conducted. It needed to be presented in terms that aligned with public expectation. Euphemism did not conceal the act so much as it made the act socially manageable. This was especially true where illegitimacy was concerned. Pregnancy outside marriage carried consequences severe enough to make discretion an urgent need. The words available to an unmarried woman were limited. She could not safely speak of abandonment, desperation, or financial impossibility. She could speak of confinement, arrangements, a good home. These terms carried an acceptable vagueness. They suggested care rather than disposal. They provided a way to move through crisis without making the crisis explicit. Operators of such arrangements relied on the same vocabulary. Advertisements promised privacy and respectability, not because these qualities were secondary, but because they were the principal goods for sale. Skill could be claimed in restrained terms. Comfort could be suggested without excess. Most crucially, outcome could be implied without being described. The language of adoption and nursing allowed a woman to believe she was purchasing care, while allowing the seller to promise nothing that could be tested. Adoption, in this setting, did not function as a defined legal process. It functioned as reassurance. It suggested permanence and safety without requiring proof. It suggested a family waiting somewhere else, a domestic endpoint that matched social ideals. It permitted the mother to imagine a respectable conclusion while avoiding the practical details that might expose the arrangement's fragility. The same was true of nursing. To say an infant was being nursed implied feeding, attention, maternal substitute. In reality, it could mean anything from genuine care to sedation and neglect. The term did not specify where the child lived, who watched it, or how long the arrangement would last. Its vagueness made it adaptable. Its familiarity made it unthreatening. Even the financial language was shaped to reduce moral friction. A fee for lodging and delivery could be described plainly. The additional lump sum for carers could be framed as a present. This word mattered. It turned a payment into a gesture. It displaced transaction into gratitude. It allowed participants to treat money as generosity rather than purchase. In practice, the present marked the moment responsibility changed hands. Once paid, it allowed the mother to step away without further obligation. It also allowed the receiver to claim, if challenged, that no sale had occurred. There had been no contract. Only assistance. Only kindness. Only arrangements made between women. This was one of the key protections of the baby farming market. It was structured to resist legal definition. A crime is easier to prosecute when it is named clearly. Theft involves property. Fraud involves misrepresentation. Murder involves a victim, an act, and a cause. Baby farming often involved all three, but not in a form that could be easily isolated. Money changed hands, but what was purchased was not a tangible object. What was transferred was a human life, but the transfer itself was not necessarily illegal. The outcome could be lethal, but infant death was common enough to blur intention. Language sustained that blur. It allowed the mother to leave without insisting on proof. It allowed the operator to receive money without producing an endpoint. It allowed witnesses, neighbors, landladies, casual observers, to accept what they saw without demanding explanation. A woman carrying a bundle could be a nurse. A midwife receiving a visitor could be attending a patient. A baby removed from a house could be taken to its new home. No one was required to ask what new home meant. The case became prosecutable only when the language failed under repetition. Walters's lodgings forced outcome into closer view. Infants appeared in a place where their presence required explanation. Their disappearance occurred too quickly and too often for nursing to retain plausibility. The same words could still be spoken, but they no longer settled the questions they were designed to settle. Once police attention was applied, language became evidence rather than protection. Terms that had been intended to reassure were treated as indicators of intent. Promises of adoption were examined against the absence of adoptive parents. Claims of nursing were weighed against the lack of continued care. The present was treated as payment rather than gesture. What had once been socially functional vagueness became, in court, strategic vagueness. This was one reason the trial could present the arrangement as method rather than misfortune. The language used by Sach and Walters did not prove murder on its own. It proved a marketplace built around concealment. It proved an agreement structured to prevent verification. It proved that the disappearance of the child was not an accident within the arrangement but a feature of it. Yet the words had not been invented by them. They were borrowed from a broader culture of discretion. They existed because the society that condemned illegitimacy also required mechanisms to manage it without disturbance. Euphemism was part of that management. It allowed women to seek solutions while preserving the appearance of moral order. It allowed operators to sell solutions without exposing their mechanics. It allowed neighbors to notice without intervening. It allowed officials to suspect without acting until the pattern became undeniable. The arrangement depended on the existence of this shared vocabulary, not because everyone was deceived, but because everyone understood that certain things were not spoken plainly. Silence was not simply imposed from above. It was maintained cooperatively, because speaking plainly risked disrupting the fragile structures that kept reputations intact. When the case forced plain meaning into public view, it did not eliminate the vocabulary. It only revealed what the vocabulary had been doing. Words had made the transaction possible by making it sound like something else. Privacy, adoption, nursing, a respectable arrangement. In the record, those terms remain as traces of a system that relied on language to keep a lethal outcome from being named until naming it was unavoidable. Chapter 10. The Limits of Prevention. The exposure of one arrangement did not produce a new set of certainties. It produced a new set of questions. After the trial, public attention turned instinctively toward prevention. If the mechanism had been revealed, then the instinct was to assume the mechanism could be dismantled. Yet prevention depended on something the city had never reliably maintained: sustained visibility of infants whose lives were easiest to lose. The gap the case exposed was not a lack of outrage. It was a lack of structure. The arrangement had functioned because it sat between systems. It was not fully medical, not fully charitable, not fully domestic, not fully commercial. It borrowed legitimacy from each without submitting to oversight from any. A midwife could operate outside institutional medicine. A nursing home could resemble ordinary lodging. A private adoption could be framed as a kindness between women. Each category provided cover, and none required the kind of documentation that would have forced continuity. Reform, where it was attempted, had to contend with that ambiguity. Any rule strong enough to prevent the worst arrangements risked constraining the informal care that many families depended upon. Paid nursing did not exist only as predation. It existed because poverty, illness, employment, and domestic instability made infant care difficult to sustain within a single household. A blanket crackdown on private nursing would have punished the poor more reliably than it punished the lethal. The city could not easily regulate a practice it also relied upon. The result was that oversight tended to cluster around what could be measured. Infant deaths that entered the coroner's system could be examined more closely. Suspicious burials could prompt questions. Known addresses could be watched. But these were reactive tools. They required a body, a complaint, or a pattern already visible. They did not reliably prevent the first death, or the 10th, if the deaths remained unlinked and unnamed. Visibility still depended on the same fragile chain as before: a child recorded as living, a carer identifiable, a movement traceable, an outcome reportable. For illegitimate infants, each link was weak. A woman who needed discretion could avoid official notice. A child could be handed over before registration, or registered in ways that offered little practical tracking. A carer could be unnamed, or named in a way that could not be checked. Addresses could change. Lodgings could be temporary. The city did not lack paper. It lacked a mechanism that insisted paper must connect from beginning to end. The case had shown what happened when connection failed. It did not automatically create connection. Even where authorities became more alert, alertness could not replace infrastructure. Suspicion could form faster, but it still required a trigger. That trigger was often social rather than institutional: a landlady who had seen too many bundles, a neighbor who had heard too much crying, a doctor who refused to sign a convenient cause. The system still depended on individuals deciding that this time, what they had noticed was worth risking comment. That risk remained real. Intervening in another household's affairs was not socially neutral. It carried the possibility of accusation, retaliation, and embarrassment. It also carried the possibility of being wrong. In a city where infant illness was common, a person who raised alarm could be dismissed as prurient or malicious. The culture of minding one's own business was not merely habit. It was a form of self-protection. Reformers could argue for regulation, but regulation had to pass through the same social terrain. The most direct approach, licensing and inspection of homes that took infants for payment, required the state to identify those homes in the first place. Yet the arrangement had shown how easily a place could present itself as ordinary. A household could take infants without declaring itself a business. Payments could be described as gifts. A midwife could receive clients privately. Inspection without disclosure was limited. Disclosure without enforcement was uneven. The case therefore produced a familiar pattern: heightened attention, partial change, gradual dissipation. It is possible, in retrospect, to treat this as failure. In the moment, it was closer to constraint. The city could not remake itself around the protection of the most precarious infants without also remaking its treatment of the women who bore them. That was the deeper condition the case revealed. Infants were vulnerable because their mothers were vulnerable, and their mothers were vulnerable because respectability was enforced through punishment. As long as shame functioned as a social tool, discretion would remain a market. As long as discretion remained a market, informal transfers would continue. And as long as informal transfers continued, death could be folded into ordinary misfortune until repetition forced it into view. The law could discourage certain practices, and it could punish when evidence accumulated. It could not easily eliminate the need that drove women toward private arrangements in the first place. It could not produce stable tracking without increasing the exposure of those most eager to remain unrecorded. In that sense, prevention was always limited by the same paradox that had enabled the crime. The people most in need of protection were also the people the system demanded be quiet. The Claymore house arrangement ended because it became visible in the wrong place, too many times, to the wrong witnesses. That is not a reliable method of prevention. It is a method of accidental discovery. The case was remembered as a warning. It did not become a guarantee. What it offered in the end was not a clear path to reform but a clear view of what reform would have required: not simply attention to baby farmers, but a change in the conditions that made it possible to purchase invisibility at all. Chapter 11. The market adapts. A public case does not end a private trade. It changes the terms under which it can be conducted. After the verdicts, the risk attached to overt arrangement increased. Names had been printed. An address had been repeated. The language of adoption and nursing had been forced into court, translated into intent, and returned to the street as warning. The city had been shown a mechanism that had previously worked because it resembled ordinary life. The response of such mechanisms is rarely disappearance. It is adjustment. The most immediate adjustment was distance. A notorious address could no longer function as a threshold in the same way, because notoriety makes observation easier. Women might still seek discretion, but discretion is undermined when a place is already associated with exposure. The value of respectability in such arrangements lies not in moral standing, but in ordinary anonymity. Once anonymity is damaged, the trade relocates. Relocation did not require elaborate planning. It required only that transactions return to ordinary domestic spaces. A lodging, a rented room, a house that appeared to contain only its occupants. The city provided endless such settings. Movement between them was common. Tenancies changed. Interiors changed. The trade did not need a permanent institution to function. It could attach itself to households temporarily, then detach when attention grew too near. Alongside distance came reduction. Large volume increases visibility. Each additional infant increases sound, supplies, waste, and the number of witnesses who might notice inconsistency. The Claymore house arrangement had been vulnerable not because it existed, but because repetition made it legible. After exposure, any continuation of similar work would have had incentive to narrow its throughput: fewer infants at a time, shorter periods of custody, fewer objects stored in quantity. The market strength had always been its ability to stay beneath the threshold of concern. After the trial, that threshold shifted lower. This did not require a change in public morality so much as a change in public imagination. Once a practice is named, ordinary sights acquire new meaning. Bundles carried through streets can be reinterpreted. Advertisements can be reread with suspicion. A nursing home can become a possible front. The city did not become vigilant everywhere, but it gained a vocabulary for unease. The trade adapted by altering its surfaces. Advertising, where it continued, could become more restrained rather than more open. It could rely less on print and more on referral. A practice that had once used public language could retreat into private recommendation, moving through networks that did not require public announcement at all. Discretion had always been the product. After the verdicts, discretion became more expensive, because it required greater caution. The second adjustment was linguistic. Certain words became contaminated. Adoption had been used too plainly and had been exposed too publicly. That did not mean the concept disappeared. It meant the phrasing could soften further, returning to the older vagueness of arrangements, placing out, kind people, respectable homes, and private care. The purpose was not only to reassure clients, but to ensure that if questioned, nothing explicit had been promised. Euphemism, after exposure, becomes more deliberate. It also becomes more defensive. A promise made too clearly is a promise that can be tested. A claim framed as suggestion is harder to prosecute as fraud. The trade had always benefited from ambiguity. A public trial taught it the value of keeping ambiguity intact. The third adjustment was procedural. One of the vulnerabilities the case had revealed was custody that could be traced. Infants moving repeatedly to the same rooms, dying under the same roof, leaving a pattern neighbors could see. After exposure, the incentive would be to shorten the visible stage. Infants would be less likely to be kept in any one place long enough for a household to become familiar with them. Transfer could occur faster. Custody could be fragmented across multiple rooms and multiple hands. Fragmentation reduces pattern. It also reduces the ability of any single witness to describe the whole chain. In court, the prosecution had been able to build a spine because a spine existed, a place of entry, a person of transfer, a place of disappearance. Break that spine into smaller segments, and responsibility becomes harder to attach to one name. This is not to claim a coordinated strategy across the city. It is to describe an ordinary response to risk. The quieter a trade becomes, the less it can be held. The fourth adjustment was in the use of respectability. Before the case, The appearance of medical competence and maternal care had been sufficient to attract trust. After the case, respectability had a second function: it became a shield against suspicion. A woman with a plausible role, midwife, nurse, lady with experience, could still operate, but the role itself would be handled with more care. The point was not to appear extraordinary. It was to appear unremarkable in a way that discouraged inquiry. The trade did not need to be believed by everyone. It needed to be accepted by enough people to proceed. Acceptance was often passive. It depended on the reluctance of others to interfere. That reluctance did not vanish with the trial. If anything, it could harden. Public cases create fear not only of perpetrators but of involvement. A neighbor who suspects wrongdoing may also suspect that speaking will pull them into court, into newspapers, into attention they cannot control. Silence remains a social habit because it remains useful. The market, therefore, did not require sympathy. It required indifference. The case had disturbed indifference briefly by forcing attention. Afterward, indifference reasserted itself in a modified form, not ignorance of the possibility, but willingness to treat the possibility as someone else's problem unless it became unavoidable. The final adjustment was temporal. Public attention fades. Outrage is not a permanent condition. The period immediately following a notorious trial may produce cautious behavior, but cautious behavior is difficult to sustain when demand persists and when enforcement is uneven. Over time, the risk of discovery is recalculated. The city returns to routine. The press turns elsewhere. The memory of the mechanism remains, but the urgency attached to it diminishes. This is how a market survives scrutiny, not by defeating it, but by outlasting it. The Claymore house case changed what could be imagined. It did not erase what could be needed. Women still face the same immediate pressures: the threat of dismissal, the risk of abandonment, the impossibility of raising an infant without support. Those pressures continued to produce clients for discreet arrangements. As long as discretion could be purchased, someone would sell it. As long as children could be transferred without reliable tracking, the trade could continue in the spaces between law and domestic life. The market adapted because it did not have to be stable to endure. It could move. It could shrink. It could change language. It could fracture its processes. It could wait. The city had seen one mechanism exposed and punished. It had not altered the conditions that made such mechanisms profitable. The verdicts had removed two names. They had not removed demand. What persisted, therefore, was not a single arrangement, but the possibility of arrangement, recreated wherever the same needs met the same silences, and where the disappearance of an infant could still be absorbed into the ordinary without immediate consequence. Chapter 12. The New Disguises. Adaptation does not always look like innovation. Often it looks like restraint. After a public exposure, the market's first priority is not expansion. It is survival. It seeks forms that produce the least friction with ordinary life, and it measures success by how rarely it is forced into contact with authority. This does not require new methods so much as tighter control over visibility. The most effective disguise is still the domestic one. A private house does not declare its purpose. A rented room does not publish a register. Neighbors may notice, but noticing is not the same as reporting. The city's daily life is filled with movements that cannot be audited: bundles carried on and off trams, women arriving with small bags, infants crying behind thin walls. A trade that attaches itself to these ordinary patterns does not need to be hidden. It needs only to avoid standing out. In that sense, the new disguises were often older disguises resumed. The case had shown one danger of scale: quantity leaves residue. Too many garments, too many bottles, too many parcels. Stored objects accumulate into evidence. A cautious operator would keep less. Acquire only what was needed for the short period an infant remained present. Dispose of items quickly. Avoid hoarding. Treat the absence of stock not as inconvenience but as protection. It is difficult to prosecute what cannot be found. Another danger revealed by the trial was the traceability of routes. Walters could be followed backward because she moved repeatedly between the same points. Her path grew familiar to witnesses. Familiarity made it describable. After exposure, any similar work had incentive to avoid repeated routes, repeated addresses, repeated times. Irregularity becomes a defensive practice: collecting in one district, lodging in another, disposing elsewhere. The point is not mystery. It is dispersion. Dispersion denies pattern. The same logic applies to personnel. A stable partnership creates efficiency, but it also creates connection. Connection, once established, allows responsibility to be shared and therefore traced. The more participants involved, the more risk of disclosure. Yet the fewer participants involved, the more each one is exposed. The market balances these pressures by using temporary links, introductions, handovers, intermediaries who do not remain in contact long enough to become legible as a network. The result is a trade that becomes harder to describe even when it persists. One reason the Claymore house arrangement could be prosecuted was that its parts were coherent. There was an entry point with a name and an address. There was a transfer stage with repeated movements. Once one part was examined, the rest could be joined. A trade that learns from this tends to break its own coherence. Instead of one address, many. Instead of one operator, several. Instead of repeated custody in a single lodging, brief custody distributed across different rooms. Instead of one set of witnesses, many partial witnesses whose accounts do not naturally align. This produces a familiar effect, suspicion without certainty. Authorities can become more alert to indicators, advertisements that promise too much, women who seem to receive infants without explanation, burials conducted with haste, but alertness is not proof. Even after a notorious case, investigation still requires a trigger that can be documented, and a chain that can be constructed. A cautious market therefore aims not to eliminate triggers entirely, but to ensure that any trigger that does occur does not attach to a usable chain. The law remains strongest where it can assign responsibility. The market remains safest where responsibility can be dispersed or denied. Language continues to serve that purpose. In the wake of exposure, adoption remains usable only when it is softened further, reduced to suggestion. Care replaces placement. Help replaces terms. A gift becomes a little something. Every phrase is chosen to avoid fixed meaning. What is offered is still an ending, but the ending is described as if it will be achieved by others, elsewhere, at some undefined later point. Promises become atmospheres rather than statements. This shift is not merely rhetorical. It affects what can be remembered and repeated. A mother who later realizes she was deceived will have less to quote and less to pin down. She can describe impressions, not agreements. The arrangement returns to the oldest protection of informal trade, the inability of participants to define precisely what they believed they were purchasing. A second protection is speed. Time produces attachment, and attachment produces questions. The shorter the period an infant remains visible to any witness, the fewer chances there are for a doctor to be called, for a landlady to notice, for a neighbor to insist on explanation. Speed also reduces the need for supplies. An infant who is present for days leaves fewer traces than one present for weeks. The most dangerous deaths are those that require paperwork. A body that must be buried requires forms. A doctor called to certify death produces statements. A coroner notified produces an inquiry. The market's safest functioning is therefore not the dramatic death but the unrecorded disappearance, an infant taken out and never seen again, removed from one person's care before formal contact can occur. Yet even disappearance is not always controllable. Infants cry. Infants fall ill. Bundles draw attention when carried too often. Domestic spaces involve witnesses who may tolerate much but not indefinitely. The market adapts by relying on the city's habits of non-interference, but habits are not guarantees. They can be broken when repetition becomes too sharp, when a witness becomes frightened, or when a single death intersects with an official who refuses convenience. This is the reality beneath the disguises. Adaptation reduces risk, it does not remove it. The city's response to exposure tends to be selective. Certain forms become less acceptable in public language. Certain addresses are watched for a time. Certain patterns become easier to suspect. But the trade survives because it is not dependent on any single form. It is opportunistic. It borrows the appearance of whatever ordinary life already provides. It does not need to persuade the whole city. It needs only to continue in the spaces where people prefer not to look. The new disguises therefore do not announce themselves. They are indistinguishable from ordinary hardship and ordinary movement. They exist as long as the conditions that produce the demand remain unchanged. Shame severe enough to make secrecy valuable, poverty severe enough to make infants a burden, and oversight weak enough that an unregistered life can vanish without immediate institutional alarm. The market's greatest protection is not the ingenuity of its operators. It is the city's continued capacity to absorb certain losses without insisting they be counted. The disguises succeed because the city has always been willing to let them. Chapter 13. The Small Transactions. The market did not survive by repeating the Claymore house arrangement exactly. It survived by returning to what had always sustained it, transactions small enough to appear ordinary. A large operation creates evidence. A small one creates ambiguity. A single infant taken into a room, kept briefly, and removed again can be explained in multiple ways, even by those who notice it. The explanation does not need to be convincing. It needs only to be plausible enough that a neighbor, a landlady, or a passerby decides the matter is not theirs to pursue. In a city dense with private lives, plausibility is often sufficient. This is why the trade tended toward the fragmentary. Instead of a fixed home, it could operate through borrowed spaces. Instead of a stable stream of clients, it could rely on occasional handovers, moving infants one at a time, at irregular intervals, through ordinary routes. This lowered risk. It also altered the nature of what could be known. A scattered trade produces witnesses who see only a piece, and pieces rarely combine into a prosecutable whole. Smallness, in this setting, is not insignificance. It is strategy. The mothers who entered these transactions were not purchasing complexity. They were purchasing an ending. The exchange did not require them to understand the chain beyond the handover point. In fact, the less they knew, the safer they often felt. A name and an address created a thread that could later entangle them. Vagueness offered a sense of protection, even when it increased danger for the child. The operators understood that dynamic and shaped the transaction accordingly. The initial contact, where it could be public at all, was likely to be cautious, modest claims, familiar phrases, an emphasis on privacy. Where contact occurred privately, the same principles applied. A kind lady was easier to trust than an obvious business. A nurse was easier to accept than an agent. The terms were presented as assistance, not commerce, and the payment was framed as practical necessity rather than price. The smaller the transaction, the less it resembled trade. This mattered because trade invites scrutiny. A business can be inspected. A business can be accused. A private kindness is harder to prosecute unless an identifiable crime is attached to it. When money was presented as contribution rather than fee, it became easier to deny that any purchase had occurred. This denial did not have to be credible in moral terms. It had to be survivable in legal terms. Small transactions also reduced the risk of material accumulation. One infant requires few supplies, and those supplies can be acquired and discarded without leaving a visible stockpile. When a room contains quantities of baby clothing, questions arise that do not arise when it contains only the ordinary disorder of living. The absence of accumulation does not prove innocence, but it makes suspicion harder to anchor. It is difficult to argue system when objects do not suggest system. The same principle applied to movement. A woman carrying an infant once is ordinary. Carrying one repeatedly from the same address is less so. Carrying one at irregular times, in different directions, with no fixed pattern, produces fewer witnesses willing to say they saw something worth reporting. Even if they did report it, irregular movement is harder to reconstruct. It creates a city-sized search area rather than a single trail. Small transactions widen the world in which an infant can be lost. This widened world offered the market a further protection, the difficulty of linking any one death to any one handover. Bodies found without identification could not easily be returned to a transaction. If an infant was never securely registered, and if the mother had left no traceable agreement, then the found body remained an isolated fact. Isolated facts do not build cases. They build rumors. The law's tools were limited by what could be demonstrated. A coroner could record an infant's death. A doctor could state likely cause. Police could ask questions. But without a mother prepared to name the person who took the infant, and without a chain that could be reconstructed, the investigation often ended where it began, with a body, an uncertain history, and a verdict that did not lead further. Small transactions were designed to keep the mother from becoming that naming witness. Not through force, but through mutual interest. The woman purchasing discretion often wanted as little record as possible. The woman selling an ending wanted the same. Both benefited from the absence of paper. Both benefited from vagueness. The trade did not need secrecy imposed from outside. It generated secrecy as part of its own terms. This is one reason the practice could persist even when publicly condemned. Public condemnation assumes that fear of exposure is enough to end behavior. But fear does not remove necessity, and condemnation does not create alternatives. A woman who cannot keep a child and cannot endure the consequences of being known to have borne it will still seek a private solution. The market remains available because it does not require public approval. It requires only private demand. And private demand rarely announces itself. In this context, the most dangerous transactions were often the most ordinary-looking ones. They took place without raised voices and without urgency visible to others. They were concluded quickly. They were framed as kindness. The money passed hands in a way that could be explained as contribution to expenses. The infant left the mother's arms and became immediately, a problem moved elsewhere. The visible world returned to normal. The mother returned to work. The household resumed its routine. The street saw nothing more than a woman stepping onto a tram with a small bag instead of a bundle. The transaction disappeared into the city's general movement, and once disappeared, it was difficult to retrieve. Small transactions did not create headlines. They created disappearance. This was how the market persisted, not through constant large-scale operation, but through countless minor exchanges that each remained beneath the threshold of sustained attention. Where the Claymore house arrangement had become legible through repetition, the small transaction survived by avoiding repetition that could be seen. It did not need to be invisible everywhere. It needed only to be ordinary enough, often enough, that when an infant vanished, the city could still treat that vanishing as one more private misfortune rather than an event demanding pursuit. Chapter 14. What could still be seen? Even at its most cautious, the market was never completely invisible. Disguise reduced attention, but it did not eliminate contact with the ordinary systems that surrounded infant life. Infants still required feeding, transport, and temporary shelter. Death still occurred in bodies that could not always be concealed indefinitely. Each of these points created friction, moments where the private transaction brushed against public process. Those moments were where the trade remained vulnerable. A doctor might still be called when an infant became suddenly ill. A landlady might still notice a pattern that did not fit the explanations offered. A burial might still require forms that did not align with the account given. The city did not become blind after a public case. It became intermittently attentive, and attention, even when brief, could still expose fragments of a larger practice. What changed was the burden of proof. Before exposure, the absence of suspicion had been the market's greatest protection. After exposure, suspicion could exist without immediately producing action. Awareness alone did not dismantle the trade. It altered the threshold at which someone decided that what they had seen required explanation. This shift was uneven. Some officials became more cautious. Some doctors refused to certify convenient causes without examination. Some coroners asked additional questions when infants appeared without clear histories. Some landlords became reluctant to rent rooms to women who appeared to take in children briefly. These changes mattered, but they were local, dependent on individual judgment rather than uniform rule. The market learned to navigate that unevenness. A cautious operator avoided places where scrutiny had increased. Movement became part of risk management. Areas with recent cases or active reformers were avoided in favor of those where oversight remained light. The city's size made this possible. Attention did not spread evenly, and neither did reform. Even where officials asked questions, answers were often sufficient if they resembled ordinary hardship. An infant could be said to belong to a relative. A nurse could claim temporary care. A mother could be described as unwell or absent. These explanations were not invented after the case. They were long-standing and familiar. Their power lay in their ordinariness. Officials were not trained to investigate every claim that resembled the normal circulation of children among poor households. Ordinary explanations remained effective because they were usually true. Many infants were, in fact, moved between relatives. Many women did nurse children temporarily. Many households were unstable. The trade did not have to fabricate an entirely false world. It needed only to align itself with the one that already existed. Where scrutiny did increase, it often stopped at description. An inquest might record that an infant had been found dead, without identifying who had last cared for it. A verdict might note probable cause without tracing responsibility backward. The process created a document, but not a pursuit. The death entered statistics without generating a case. This distinction mattered. Documentation creates the appearance of oversight. Pursuit creates risk. The city was better equipped to do the former than the latter, particularly when victims could not be named and when witnesses were reluctant to implicate themselves by speaking. The most visible point of friction remained burial. An infant body required disposal, and disposal still intersected with regulation. Cemeteries required certificates. Undertakers required instruction. Even where arrangements were informal, a body could not always be removed without someone noticing. The risk of this stage could not be eliminated entirely. It could only be managed by speed, distance, and explanation. Speed reduced witnesses. Distance reduced connection. Explanation reduced suspicion. These were the same tools the trade had always used. The difference after exposure was that they were applied more deliberately. Yet despite this caution, cases continued to surface. Not all trades adapted equally well. Not all participants were careful. Not all deaths could be absorbed quietly. When bodies were discovered repeatedly in a particular area, or when the same names appeared too often in unrelated inquiries, suspicion could again condense into pattern. The market's survival depended on fragmentation, but fragmentation could fail. When it did, the exposure looked familiar. A house that received too many infants. A woman who could not account for outcomes. Objects that accumulated beyond plausible need. A death that intersected with an official unwilling to accept convenience. The difference was scale, not form. Post-exposure cases tended to be smaller, harder to prosecute, and less likely to reach national attention. They did not always produce executions. They produced warnings, fines, closures, occasional imprisonment. The market adjusted to that level of risk because that level of risk was survivable. What remained consistent was the gap between what could be seen and what could be acted upon. The city could see more than it could pursue. It could record more than it could connect. It could condemn in general terms while tolerating specific arrangements that remained difficult to pin down. Awareness altered the landscape, but it did not redraw it entirely. The trade persisted in that space, not hidden but dispersed, not unknown but rarely traceable, not unobserved, but seldom pursued to conclusion. What could still be seen was enough to know the problem had not ended. What could not be seen, how many infants passed through the same quiet transactions without ever intersecting with record, remained, as it had always been, beyond counting. The market survived not because the city failed to notice, but because noticing was rarely enough. Chapter 15, The Work of Forgetting. A city does not remember by default. It remembers by repetition, and it forgets by routine. After a public case, there is a period in which attention sharpens. Names are spoken more often. Certain phrases acquire weight. Ordinary sights are reinterpreted through the lens of what has been exposed. For a time, the mechanism remains close to the surface of public thought. Then the city resumes its habits. For most people, survival requires this resumption. A metropolis cannot remain in a state of moral alertness indefinitely. Outrage is exhausting. Fear is impractical. Daily work, rent, illness, family obligation, these do not pause to accommodate reflection. Memory, in the collective sense, begins to narrow into what is easiest to carry. In this narrowing, the case becomes story rather than warning. It is reduced to a set of fixed points: 2 women, a house, dead infants, a trial, an execution. These elements are retained because they are simple, legible, and conclusive. They provide the satisfaction of an ending. They allow the public to believe that the danger has been identified and removed. What falls away are the conditions. The social pressures that created demand, the economic realities that made infants negotiable, the administrative gaps that allowed disappearance to pass without record, these are less comfortable to hold, because they do not resolve. They implicate ordinary life. They require the city to recognize that what happened was not a singular eruption of cruelty, but a predictable outcome within familiar structures. Forgetting, in this setting, is not passive. It is work. It is performed through language. The case is described as exceptional, monstrous, aberrant. Those words do not merely condemn. They isolate. They place the crime at a distance from everyday practice, and therefore protect everyday practice from examination. If the perpetrators are treated as unnatural, the system that enabled them can remain natural, unchanged, and largely unnamed. Forgetting is also performed through administration. Once the verdict is delivered and punishment carried out, files are closed. The investigation ends. No further resources are committed. The matter becomes archival rather than active. This closure is functional. It allows the state to move on. It also ensures that what cannot be easily measured, unidentified infants, unrecorded transactions, vanished women, remains outside institutional concern. The archive preserves what is needed to prove a case, not what is needed to understand a world. The public record mirrors this. Newspapers retain the story as a moral event, but moral events are consumed and replaced. The case may be referenced later as shorthand for a danger, but the reference grows less precise with time. Details shift. Emphasis changes. The narrative hardens into the version that is easiest to repeat rather than the version most closely tied to evidence. Over time, the case can become both famous and flattened. A name persists while its context dissolves. An address persists while its rooms are repurposed. A phrase persists, baby farming, while its broadness allows it to be used without specificity. The result is a paradox. The case remains known, but what it revealed becomes less clear. This forgetting serves a function. It protects those who benefited from discretion without naming them. It protects institutions by treating failure as anomaly. It protects the public from the discomfort of recognizing how much of the arrangement relied on their own habits, the reluctance to ask questions, the readiness to accept euphemism, the willingness to treat certain losses as inevitable. It also protects the market. A trade that depends on silence does not need absolute silence. It needs enough silence, often enough, that transactions can be conducted without producing sustained scrutiny. Forgetting restores that silence. Not by erasing knowledge entirely, but by returning knowledge to the status of background unease, present, but not mobilizing. The work of forgetting is visible in what disappears first. The victims do not remain. Most infants cannot remain, because their names were never secured. Their bodies, if found, become cases without identities. Their brief lives do not lend themselves to story, because story requires continuity. The mothers also fade, because their privacy was the condition of their continued survival. Even when a mother's name exists in the record, it is rarely repeated outside it. Silence returns around her. What persists most reliably is the spectacle of punishment. Executions are easy to remember because they provide finality. They transform diffuse harm into a single dramatic conclusion. They allow a community to feel that something has been done. They permit relief, and relief is a strong incentive to move on. Yet the case itself had shown that punishment does not equal prevention. The mechanism had operated because it was compatible with ordinary life. It did not require extraordinary evil. It required ordinary pressures and ordinary indifference. To remember the case fully would mean remembering that compatibility, and that is precisely what the city resists, because it threatens the comfort of believing the danger lay only in two individuals. So the case is remembered in the way that makes continuation possible. Two women are condemned. A house becomes notorious and then becomes a house again. The city reassures itself that the matter was resolved. Meanwhile, the conditions that made disappearance purchasable remain largely intact. Forgetting, then, is not a failure of memory. It is the restoration of a usable world. And in that usable world, the trade does not need to announce itself. It can return to small transactions, private arrangements, and the quiet movement of bundles through crowded streets, confident that even if the city has heard the story before, it will not hold it close for long. Chapter 16. What Remained Unsaid. Forgetting did not erase the case entirely. It narrowed what could be spoken. After the period of public attention passed, references to the crime became indirect. The language shifted away from specifics and toward general caution. Officials spoke of the need for vigilance. Reformers spoke of dangerous practices. Newspapers invoked past cases without repeating their details. The names that had once carried weight were mentioned less often, and then mainly as examples rather than subjects. This narrowing was deliberate as much as it was gradual. To speak too precisely risked reopening questions that had no administratively comfortable answers. How many infants had passed through similar arrangements? How many deaths had never been identified? How many women had paid for discretion and never learned the outcome? These were not questions institutions were equipped to resolve, and so they were questions institutions learned not to ask aloud. Silence, once restored, became part of stability. Within professional circles, medicine, policing, local administration, knowledge of the case persisted in fragments. A midwife might be warned informally about conduct that could be misconstrued. A doctor might be reminded to insist on proper examination. A coroner might approach certain cases with more caution. These were adjustments of practice rather than declarations of policy. They did not generate new rules so much as new hesitations. Hesitation is harder to measure than reform. It leaves no paper trail. It cannot be cited as evidence of change. It exists in decisions not made and questions not pursued. For the market, hesitation could be inconvenient. For the city, it was manageable. It allowed officials to feel responsive without committing to structures that would require sustained oversight. The women most affected by the case remained largely outside these conversations. They were not included in discussions of prevention or reform. Their circumstances were treated as background conditions rather than as subjects of inquiry. The pressure to avoid disgrace remained intact. The cost of visibility remained high. In this sense, the case altered professional behavior more than it altered private reality. What also remained unsaid was the extent to which the city itself had relied on the same mechanisms. Informal infant care was not an aberration at the margins. It was woven into ordinary survival. Families used it when illness intervened. Employers relied on it when domestic arrangements failed. Parishes tolerated it when alternatives were insufficient. To speak openly about its dangers was to speak openly about its necessity, and necessity complicates condemnation. So discussion retreated to safer ground. Condemnation focused on excess, on cruelty, on those who went too far. The implication was that the practice itself could be safe if conducted with proper care. This framing preserved the market's legitimacy while distancing it from its most lethal expressions. It allowed society to believe it had learned a lesson without dismantling the structure that had produced the case. In this way, silence performed a sorting function. What was retained was what could be acted upon without disruption. What was omitted was what would have required fundamental change. The case became an object lesson in individual depravity rather than a catalyst for structural reckoning. The archive reflects this choice. Documents record the trial, the verdict, the execution. They record recommendations made in response to public concern. They do not record systematic follow-up. They do not record a sustained effort to trace missing children or to audit past arrangements. The silence in the record is not accidental. It marks the point at which attention ceased to be useful. Yet even silence has limits. From time to time, another case surfaced that resembled the one that had been closed. When it did, it was described as disturbingly familiar. The comparison was implicit rather than explicit. The earlier case functioned as a reference point without being reopened. It was present as memory, but not as inquiry. This was the compromise the city maintained. Enough memory to recognize danger when it repeated too closely. Enough forgetting to allow ordinary life to proceed without constant disruption. Between these poles, the trade persisted, adjusting its forms while relying on the same absences. What remained unsaid, then, was not ignorance. It was acknowledgement without pursuit. The city knew more than it admitted. It acted less than it could have. The case had revealed a mechanism, and that mechanism remained lodged in public consciousness as a possibility rather than as a problem requiring continuous action. This was the final accommodation. The arrangement that had once been respectable could no longer be defended openly, but neither could it be eliminated without confronting the conditions that sustained it. Silence bridged that contradiction. It allowed condemnation and continuation to coexist. And in that coexistence, the most vulnerable lives remained the least securely held, present enough to be known in the abstract, absent enough to vanish without demanding speech. Chapter 17. The Men Around the Case. The case was prosecuted as the work of two women, but it did not unfold in isolation from men. Men appeared throughout the record, not as protagonists, but as functionaries, police officers, doctors, coroners, magistrates, landlords, clerks. They did not organize the arrangement, but they encountered its effects. Their roles shaped what could be seen, what could be asked, and what could be carried forward into official action. None of them were required to understand the whole. Policing entered the case late, and unevenly. Before suspicion formed, officers encountered infants only incidentally, as bodies discovered in public places, as deaths reported without clear histories, as domestic matters that did not yet meet the threshold for intervention. A single dead infant, without identification, did not automatically indicate a crime that could be pursued. It indicated a tragedy that could be recorded. Recording was not the same as investigating. Once Walters's lodgings became visible as a repeated site of infant presence and death, policing acquired a focus. That focus narrowed the inquiry. It also clarified it. Police work in this period relied heavily on location, movement, and witness recollection. When infants could be linked to a place and a person, action became possible. When they could not, the matter stalled. Doctors occupied an earlier point of contact. They were often called when an infant was already dying or already dead. Their task was not to reconstruct a life, but to identify a cause. In an era of high infant mortality, this task was complicated by familiarity. Many causes of death were common, and few left distinctive marks. A doctor who certified convulsions, debility, or failure to thrive was not necessarily careless. He was operating within the limits of contemporary understanding and expectation. What changed in the case was not medical knowledge, but context. When chlorodyne was introduced into testimony, it gave doctors a vocabulary for intention. A substance with known sedative properties could shift a death from misfortune to act. That shift mattered because it allowed medicine to align with prosecution. Without it, medical opinion might have remained descriptive rather than accusatory. Coroners stood at the boundary between medicine and law. Their inquiries determined whether a death remained private or became public. An inquest could compel testimony. It could summon witnesses. It could insist on detail where detail was inconvenient. Yet coroners also worked within practical constraints. They dealt with volume. They relied on cooperation. They could not pursue every case as if it concealed a crime. Most infant deaths passed through their hands without producing further action. In the Sach and Walters case, the coroner's involvement mattered because repetition forced attention. A single unexplained death could be absorbed. Multiple deaths with overlapping circumstances demanded explanation. Once that demand was made, the coroner's court became a staging ground where fragments could be assembled into something resembling narrative. Magistrates and judges entered only once the case had been shaped. They did not investigate. They did not speculate. Their task was to determine whether the evidence presented met legal standards. They dealt in admissibility, relevance, and proof. The broader social conditions that had enabled the arrangement were largely outside their remit. Their focus was necessarily narrow. This narrowing was not a failure of conscience. It was a function of role. A magistrate could not ask how many infants had died elsewhere. He could ask whether the infant before him had been murdered. A judge could not demand reform. He could impose sentence. The court's authority ended where its jurisdiction did. Landlords and landladies occupied a more ambiguous position. They were often the first to notice irregularity. They observed comings and goings. They heard crying. They saw bundles appear and disappear. Their power, however, was informal. They could question, complain, or evict. They could also decide that what they observed was none of their business. That decision was shaped by fear of accusation, fear of loss of income, and fear of entanglement with authorities. In this sense, they functioned as gatekeepers of visibility. When a landlord chose silence, the arrangement remained private. When a landlord chose to speak, the arrangement moved closer to scrutiny. The case record suggests both reactions occurred, at different times, with different consequences. Clerks and registrars appear only faintly, but their absence is instructive. Birth registration was inconsistent. Death registration depended on information provided by others. A clerk could record what was told to him, but he could not verify what was omitted. The system assumed honesty at points where honesty was not always safe for participants. As a result, records existed without connection, and connections existed without records. This was not deception by officials. It was structural limitation. What unites these men is not complicity, but compartmentalization. Each performed a role defined narrowly enough that the larger mechanism could pass through without being fully apprehended. No single man in the record was responsible for seeing the whole. No single role required that the whole be seen. The arrangement exploited that fact, not by subverting authority, but by fitting neatly between its functions. The case came together only when those functions briefly aligned. A landlord noticed repetition. A doctor questioned cause. A coroner convened an inquiry. Police traced movement. A court accepted a chain. This alignment was rare. It depended on timing, proximity, and the willingness of individuals to push beyond convenience. After the verdicts, that alignment dispersed again. The men returned to their roles. Policing resumed its broader concerns. Doctors continued to certify deaths in difficult circumstances. Coroners managed volume. Courts moved on to new cases. The system did not change its structure because the structure had not been designed to prevent what had occurred. It had been designed to manage it once it became undeniable. The men around the case were therefore not absent. They were present in ways that mattered, and absent in ways that allowed the arrangement to function. Their presence explains how the case could be prosecuted. Their absence explains how it could exist for so long. Between those two facts lies the mechanism the book has traced, a crime that did not require conspiracy, only coordination through ordinary roles that never required anyone to ask what lay beyond their immediate responsibility. That, more than any individual failure, is what the case revealed. Chapter 18, The Shape of Responsibility. By the time the case was concluded, responsibility had been assigned in a form the law could accept. 2 women had been named. 2 women had been judged. 2 women had been punished. This assignment satisfied the requirements of prosecution and allowed the machinery of justice to disengage. It also produced a shape of responsibility that was narrow by design. Responsibility, in this case, was made to fit persons rather than processes. The court did not deny that wider conditions existed. It simply had no mechanism to address them. Responsibility had to be located where intent could be demonstrated and where action could be described as criminal rather than customary. The arrangement itself, its reliance on discretion, its use of euphemism, its movement through private space, remained largely outside the frame of judgment. This narrowing was not accidental. It was necessary. A system cannot be punished in the way an individual can. It cannot be imprisoned or executed. It can only be regulated, restructured, or ignored. In the absence of political will or administrative capacity to do the first 2, the law defaulted to the third once the individuals at the center had been removed. The case therefore closed around its most visible actors. Sach's authority as a midwife made her legible as an origin point. Walters's handling of infants made her legible as an endpoint. Between them, a chain could be drawn that satisfied legal logic. Beyond them, responsibility diffused into a field the court could not easily traverse. The mothers were not held responsible, because responsibility would have been incoherent there. Their actions were shaped by coercive social conditions rather than by profit. To prosecute them would have exposed the law's own complicity in punishing illegitimacy more harshly than harm. That contradiction was avoided by treating them as witnesses rather than participants. The men around the case were not held responsible, because responsibility would have exceeded role. A doctor who certified death without suspicion acted within accepted practice. A coroner who closed an inquest without identifying a culprit acted within his remit. A landlord who chose not to interfere acted within social norms. None of these actions, taken alone, could be framed as criminal negligence without challenging the structures that defined them as ordinary. Responsibility therefore settled where it could be contained. This containment produced clarity at the cost of completeness. The verdicts answered the question of guilt in a way that could be enforced. They did not answer the question of how many deaths had been enabled by the same arrangement elsewhere, or how many lives had been shaped by the same pressures without ever intersecting with record. Those questions remained unanswered not because they were unimportant, but because they could not be resolved through punishment alone. The public narrative followed the same contour. Responsibility was understood as something that belonged to bad actors rather than to tolerated practices. This understanding made outrage manageable. It allowed condemnation without self-examination. It permitted the city to believe that removing certain people restored moral order, rather than revealing its fragility. Yet the case itself had shown how easily responsibility could be passed along. A mother passed responsibility under pressure. A midwife passed responsibility for outcome. A carrier passed responsibility through movement. An official passed responsibility through certification. At each point, the transfer was socially intelligible. At no point did it require an explicit decision to kill. Death emerged as the endpoint of accumulated abdication rather than of a single dramatic act. This is why responsibility, once narrowed, was also distorted. To place full responsibility on two individuals was legally effective, but analytically incomplete. It explained how the arrangement ended, not how it began or how it persisted. It converted a mechanism into a crime and in doing so allowed the mechanism itself to fade again into background conditions. The case did not challenge the city's understanding of responsibility. It confirmed it. Responsibility was something assigned after harm became visible, not something maintained continuously. It was something that could be localized, punished, and then set aside. The idea that responsibility might be distributed across ordinary roles, and that harm could result from their interaction, remained largely unexamined. This is not a claim of collective guilt. It is an observation of structural design. The law was never intended to manage the quiet disappearance of those whose lives were difficult to hold within record. It was intended to respond when disappearance became undeniable. The Sach and Walters case crossed that threshold. Many others did not. In that sense, the shape of responsibility that emerged from the case tells us less about moral clarity than about institutional capacity. It shows where responsibility can be fixed, and where it cannot. It shows what kinds of harm can be named, and what kinds remain ambient. It shows how a city can condemn a crime without confronting the arrangements that make it possible. What follows, then, is not a conclusion in the ordinary sense. It is an accounting of what this case can, and cannot be asked to bear. Chapter 19, The Threshold. There is a point at which private harm becomes public matter. The case against Sach and Walters reached that point not because the suffering involved was uniquely severe, but because it became legible. It crossed the threshold where the city could no longer treat disappearance as a private outcome, and where officials could no longer accept ordinary explanations without risking their own credibility. This threshold is not fixed. It moves. It moves with class, with location, with the social standing of those involved, and with the administrative appetite for inquiry. It moves with the availability of a body. It moves with whether a witness is willing to speak. It moves with whether a death can be made to fit a charge. Most infant deaths never reached it. They remained within households, within lodging rooms, within the vocabulary of weakness and misfortune. They were absorbed into statistics and burial registers without provoking sustained attention. Even when deaths were suspicious, suspicion alone was often insufficient to produce pursuit. The city did not lack sympathy in the abstract. It lacked a mechanism that demanded action each time a child vanished. The Claymore house arrangement crossed the threshold because it accumulated the wrong kind of visibility. Repeated movement between the same points created trace. Repeated infant presence under the same roof created witnesses. A death occurring too close to ordinary domestic observation created questions. Once questions were asked, the lack of documentation that had protected the arrangement became an exposure. The system could not supply the reassuring continuities it had implied. At that moment, the city required an answer. The answer was produced in the form the law prefers, a narrative with names, roles, and intent. The prosecution did not need to prove every death, only enough to make the method undeniable. It needed a mother who could testify, an infant whose death could be medically described, and a chain of custody that could be reconstructed. Those elements allowed the arrangement to be transformed into a case. A case is one of the most powerful forms of attention. It takes dispersed suspicion and concentrates it. It compels testimony. It turns objects into exhibits. It converts private knowledge into public statement. It fixes the sequence of events into a record that can be cited, repeated, and used to justify punishment. But a case also imposes boundaries. It frames what can be asked. It defines what counts as relevant. It sets aside what cannot be proven. It offers closure not necessarily where closure exists, but where closure is institutionally achievable. This is why the threshold matters. Once harm crosses it, the harm becomes visible enough to be punished, but not necessarily visible enough to be fully understood. The court can name perpetrators and still leave victims uncounted. It can expose a mechanism and still leave the conditions that sustained it intact. Below the threshold, the market persists as routine. Above it, the market becomes scandal. The distance between routine and scandal is often only a handful of decisions: a landlady who speaks instead of ignoring, a doctor who refuses to certify without question, a coroner who insists on a fuller account, a police officer who follows a movement that might otherwise be dismissed. These decisions are not common enough to be a reliable form of protection, but when they occur together, they can shift a private arrangement into public scrutiny. The Sach and Walters case shows the threshold in operation. It reveals how long the arrangement could function without crossing it, and how quickly the machinery of prosecution engaged once it did. It demonstrates that a crime can exist in ordinary life until ordinary life becomes unwilling to contain it. It also demonstrates something less comforting, that the majority of cases never acquire the conditions necessary to cross the threshold at all. A baby found without identification may produce an inquest and nothing further. A woman who paid for discretion may never speak. A death that appears as weakness may never be questioned. An arrangement that stays dispersed may never gather into pattern. In these circumstances, harm remains private, and privacy is both its shield and its erasure. The threshold is therefore a measure of institutional attention, not of suffering. The suffering that occurred below it was no less real. It was simply less usable to the law, less legible to the archive, less able to disrupt the city's habit of moving on. The Claymore house arrangement was interrupted because it became usable. That is what its exposure ultimately demonstrates, not the certainty that justice prevails, but the conditions under which justice can be made to act at all. What follows must be read with this in mind. The case provides a window into a practice that was otherwise designed to leave no window. It offers evidence where so often there is only implication. It makes visible for a moment a mechanism that depended on remaining unseen. But it cannot claim to represent every instance of the trade. It cannot restore the names that were never recorded. It cannot lift every disappearance above the threshold. It can only show with precision what happened when one arrangement failed to remain invisible, and what that failure reveals about the city that contained it until it could not. Chapter 20. The ending the law allows. The case ends where the law can end it. It ends with conviction, sentence, and execution, formal acts that convert uncertainty into conclusion. This ending is not the same as resolution. It is a boundary drawn around what can be proven and punished, and it is presented as final because institutions require finality to move forward. Within that boundary, the story is coherent. There is an address where women arrived in secrecy. There is money exchanged for privacy and outcome. There is a transfer of infants into other hands. There is a method by which life is extinguished without spectacle. There is a chain of witness testimony sufficient to establish one death beyond doubt and to render the wider arrangement intelligible as deliberate practice. This is what the law allows itself to hold. It does not allow itself to hold the full number of infants unaccounted for, because the record cannot carry them with certainty. It does not allow itself to hold the full range of transactions that left no witnesses willing or able to speak. It does not allow itself to hold the conditions that produce demand, because those conditions are not crimes in the way a court can name crime. So the case ends with people rather than with structures. It is easier to punish persons than to reform the social economy that made their work profitable. Punishment offers the appearance of correction. It satisfies a public need for moral clarity. It also provides a stopping point. A society built on routine cannot afford endless inquiry into its own failures. In this sense, the legal ending performs a civic function. It concentrates harm into a manageable narrative and then closes it. It turns a diffuse, ambient vulnerability into a discrete event, this case, these offenders, this conclusion. Once the event is concluded, attention can be withdrawn without the sense that abandonment is occurring, because closure has been declared. This is the point at which the broader world reasserts itself. Mothers continue to require discretion. Infants continue to be born into precarious circumstances. Informal care continues to exist as a necessity for the poor and a convenience for others. The market adapts, contracts, disperses, and continues. Most of it remains below the threshold at which the law can intervene. The ending the law allows is therefore also an ending that makes continuation possible. It permits the city to treat the case as an aberration rather than as a symptom. It confirms that punishment exists, and in doing so it reduces pressure to re-examine the ordinary arrangements that functioned alongside the lethal ones. It preserves the idea that danger can be excised without altering the environment in which it grew. The record reflects this. The transcripts, reports, and summaries preserve what mattered to prosecution: a chain, a cause, a verdict. They do not preserve what mattered to those who vanished without witness: the infants without names, the transactions without paper, the women who returned to their lives carrying the knowledge that they could not safely speak. This absence is not a narrative choice. It is the outcome of the system the case moved through. Even where later reform discussions invoke the case, they tend to do so in a way that confirms closure. The case becomes reference, warning, example. It is used to justify vigilance and regulation. It is rarely used to revisit the deeper contradiction that made the market viable, a society that demanded discretion so urgently that discretion could be purchased from those willing to sell it at any cost to the child. The ending the law allows leaves that contradiction intact. It is tempting, after such a case, to search for the final moral lesson. The record does not support one. What it supports is something simpler and more difficult to accept: that harm can be made routine when it aligns with social convenience, and that interruption depends on visibility more than on conscience. The Claymore house arrangement was interrupted because it became visible. It became visible because repetition produced pattern. Pattern drew attention. Attention produced documentation. Documentation produced a case. The case produced an ending the law could enforce. This sequence is not comforting, but it is accurate within the limits of what survives. It tells us what can be proven and what cannot. It shows how an arrangement can operate as long as it remains compatible with the city's habits. It shows how the law, when it acts by narrowing reality into a form that can be concluded. The case ends here because that is where the record becomes most decisive. Beyond this point, the story does not stop, only the part that can be held with certainty. Everything else continues in quieter forms: the need, the market, the silences, the movement of infants through spaces that still resist documentation. The ending the law allows is not the ending the world receives. It is simply the point at which the world is permitted to look away again. Chapter 21: What this case can hold. This case cannot hold everything it exposed. It can hold a mechanism at the moment it failed. It can hold a set of roles briefly aligned. It can hold the narrow slice of harm that crossed the threshold into documentation and judgment. It cannot hold the full extent of what passed through the same spaces before and after, because the conditions that made the arrangement workable were designed to resist being held. That resistance is part of the story. Claymore House was not remarkable because it hid violence especially well. It was remarkable because it did not need to. The arrangement relied on habits that were already in place: discretion valued over verification, euphemism preferred to clarity, private solutions accepted as necessary. These habits did not originate with the individuals prosecuted. They preceded them and outlasted them. What the case allows us to see, briefly and clearly, is how those habits interact. A woman under pressure seeks privacy. Privacy is sold as respectability. Respectability removes scrutiny. Removal becomes disappearance. Disappearance becomes death that cannot easily be traced. At no point does this sequence require a single dramatic decision. It requires only that each step be treated as ordinary by the person responsible for it. That ordinariness is what allowed the arrangement to function for as long as it did. The record preserves the point at which ordinariness failed. Once repetition produced pattern, the language that had smoothed the exchange lost its power. Once pattern demanded explanation, the absence of documentation became evidence. Once evidence accumulated, responsibility could be shaped into a form the law recognized. That shaping produced a conclusion that felt decisive because it was enforceable. But enforcement is not comprehension. To understand what this case reveals is not to multiply speculation, nor to assign guilt where proof does not survive. It is to recognize the limits of what survives at all. The archive records the moment of collision between a private trade and public authority. It does not record the countless transactions that never collided. Those transactions matter not because they can be reconstructed, but because they explain why this case cannot be treated as isolated. The city in which Claymore House operated was not uniquely corrupt. It was structured around pressures that made invisibility valuable and oversight conditional. That structure did not vanish with the execution of 2 women. It adjusted, as structures do, and continued to produce the same vulnerabilities in quieter forms. This is why the case endures. Not as a catalogue of atrocity, and not as a moral fable, but as a demonstration of how harm can be organized without appearing extraordinary. It shows how legality, respectability, and indifference can coexist with lethal outcome. It shows how responsibility can be distributed thinly enough that it is only gathered when something goes wrong. The infants who cannot be named remain outside the frame, not through neglect of the historian, but because the system that failed them never required their names to function. Their absence is not a gap to be filled by imagination. It is evidence of how completely their lives were made provisional. The mothers who could not return remain similarly constrained. Their silence is not mystery. It is consequence. What this case can hold, finally, is a boundary. It marks the point at which the arrangement ceased to be absorbed as private and had to be treated as public. It shows the conditions under which the law can act, and the much wider conditions under which it cannot. It reminds us that exposure is not prevention, and that punishment is not cure. The story ends here because certainty ends here. Beyond this point lie questions that cannot be answered without leaving the record behind. This account does not do that. It stops where evidence stops, and where stopping itself becomes part of what must be understood. The arrangement could no longer remain invisible. That is what brought it into view. What remained invisible, before, after, and elsewhere, defines the limits of what this case can be made to explain. Chapter 22, The Silence That Stayed. After the case, the city retained knowledge and returned to silence. The knowledge was not evenly distributed. Most people encountered it as headline and rumor, then as a reference, then not at all. Those closer to the machinery of the case, police, doctors, coroners, landlords, carried it as caution. Those who had entered the arrangement as clients carried it differently, as threat, as shame, as confirmation that what they had tried to keep private could become public. Silence served each group for different reasons. For officials, silence was the natural condition of concluded work. Cases ended. Files closed. Attention moved. The system did not reward continuous revisiting of resolved matters. It rewarded forward motion, new prosecutions, new conclusions. For the public, silence was relief. A case of infant killing was unbearable as a permanent presence. To return to ordinary life required that it become past. For women who had used similar arrangements, silence remained protective. The case did not lessen the risks attached to illegitimacy. It did not grant safety to those who admitted having paid for discretion. It did not create a space where a mother could publicly seek answers without inviting judgment. Even when sympathy existed, it was unreliable. Silence continued to offer what the city still refused to provide, the possibility of surviving without being defined by one crisis. The market depended upon this. Not because everyone was ignorant of the danger, but because speaking had costs. A woman considering a discreet solution faced immediate consequences if her pregnancy became known. Those consequences were concrete: dismissal, eviction, abandonment. The potential danger to the child was real but abstract, located in a future that could be hoped against. In that balance, silence remained the rational choice, even when it was also the tragic one. The case made this logic visible without changing it. Public condemnation offered no alternative that could match the urgency of need. Reform discussions rarely reached the women who most required practical support. Charitable structures were uneven. Institutional care carried its own stigmas and risks. The most consistent resource remained private arrangement, and private arrangement remained safest when it remained unspoken. So the silence stayed, not as ignorance, but as practice. It was reinforced by the way the case was remembered. The story that survived most clearly was the story of perpetrators, named, prosecuted, punished. The story of demand was less frequently told, because demand implicated ordinary society. It required acknowledgement that the city's moral code created the conditions for clandestine markets. That acknowledgement was possible, but it was not comfortable. Comfort, after a case like this, is often purchased by simplification. 2 women were blamed. 2 women were removed. The matter was treated as solved. In that solution, silence became legitimate again. It became a form of closure rather than a form of concealment. The city could believe it was no longer complicit in looking away, because the law had looked, briefly, decisively, and declared an end. Yet the case itself had shown that looking was rare. It occurred only when a pattern became undeniable. Denial was the default because denial allowed life to proceed. The arrangement had been able to operate because it relied on that default. After the trial, the default returned, altered only by a lingering awareness that did not consistently translate into action. Silence is often misread as absence of feeling. In this context, it was more often the management of risk. It was the decision to protect a livelihood, to preserve housing, to avoid disgrace, to keep a fragile stability intact. Silence did not mean approval of what occurred. It meant the world offered few safe ways to respond. This is why the case remains, even now, difficult to close cleanly. The executions provide a stopping point, but silence extends beyond it. It reaches backward into the years before discovery, when infants vanished without inquiry. It reaches forward into years after, when arrangements continued in smaller forms. It fills the archive where names should be, and it shapes the public memory into something tidy enough to carry. What the record shows is not only what was said in court. It shows what could not be said anywhere else. The women who did not speak remain uncounted. The infants who could not be named remain unclaimed. The ordinary pressures remain largely unaddressed. The silence that stayed is therefore not merely a gap in knowledge. It is a continuation of the same mechanism the case exposed, a system that treated certain lives as negotiable and then treated their loss as absorbable. The case interrupted an arrangement. The silence ensured that the conditions for similar arrangements remained intact. And in that sense, silence is not what follows the story. It is what runs through it from the beginning. Chapter 23, What Remains. This account ends where certainty ends. It does not end with reform, because reform was partial and uneven. It does not end with prevention, because prevention depended on conditions that were never fully altered. It does not end with knowledge restored, because much of what was lost was never recorded in a form that could be recovered. It ends with what can be said without invention. The Claymore house case shows how a crime can exist without secrecy, how harm can be organized through ordinary roles, and how responsibility can be narrowed until it fits the limits of law. It shows how respectability can function as protection rather than virtue, and how discretion, when made a commodity, can absorb lives without demanding account. It also shows the limits of exposure. Visibility interrupted one arrangement. It did not dismantle the market that made that arrangement profitable. The city learned how the mechanism worked, but it did not remove the pressures that fed it. Women continued to face consequences severe enough to make silence rational. Infants continued to be born into circumstances where their survival depended on systems that did not reliably insist on continuity. What the case leaves behind is not a lesson in individual cruelty, but a map of vulnerability. It marks the points where harm passed unchallenged because it aligned with expectation. It marks the moments where attention became unavoidable, and the narrow corridor through which that attention could move. It marks how quickly outrage can produce punishment, and how slowly it produces structural change. The infants who died remain largely without names. That absence is not a failure of sympathy. It is evidence of how completely their existence was made provisional. The mothers who paid for discretion remain largely silent, not because they lacked feeling, but because the world offered them few safe alternatives. Nothing in this account redeems what occurred. Nor does it require embellishment to make it meaningful. The facts that survive are sufficient. They show that harm does not always announce itself as violence, and that the most dangerous arrangements are often those that resemble ordinary solutions to ordinary problems. The story has been told here without speculation, because speculation would offer false completeness. It would fill gaps that are themselves part of the truth. The silences matter. The missing names matter. The inability to count matters. This case matters not because it was unique, but because it was briefly visible. It allows us to see how easily lives can be transferred, diminished, and erased when systems value order over outcome. It allows us to see how law intervenes only when disappearance becomes inconvenient. It allows us to see how memory narrows until what remains is bearable. Nothing further can be concluded without leaving the record behind. What can be concluded is this: the arrangement failed not because it was discovered immediately, but because it persisted long enough to become legible. Most arrangements did not fail in that way. They remained small, dispersed, and absorbable. The law acted where it could. The city returned to routine. The conditions remained. That is what remains when the case is finished. Epilogue. The case has an ending. The world that produced it does not. In court, the narrative was made manageable. It was narrowed to what could be proven, attached to names that could be punished, and concluded with sentences that allowed the machinery of justice to stop. That conclusion served a purpose. It provided an answer the city could accept, and a point at which attention could be withdrawn without appearing indifferent. This is what a usable ending does. It converts a mechanism into a story with a final act. It turns distributed responsibility into individual guilt. It places disorder outside the ordinary and declares that it has been removed. The public can then return to routine with the reassurance that something decisive has occurred. But the record, even at its most complete, shows the limits of that reassurance. The arrangement depended on pressures that were not criminal in themselves and therefore were not tried: the threat of disgrace, the scarcity of support, the fragility of women's livelihoods, the ease with which an infant could exist only briefly within official sight. These were not incidental conditions. They were the environment. The case exposed them only indirectly, because the law had no way to prosecute a social structure. This is why the same pattern could recur. A city that punishes visible need creates demand for invisible solutions. A system that does not reliably track the lives of the most vulnerable cannot reliably detect their disappearance. Where money can purchase discretion, discretion can purchase erasure. Those facts do not require melodrama. They require only that ordinary life continue to value quiet over accounting. The Claymore house case is preserved because it crossed the threshold into proof. It did so through coincidence and repetition, the wrong movements, too often, in the wrong place. It became legible enough to prosecute. That legibility is rare. It produces an archive, and the archive produces memory. Outside the archive, most lives involved in such arrangements remain unheld. The infants remain largely unnamed. The women remain largely silent. The transactions remain largely untraceable. This is not a sentimental observation. It is the factual boundary of the historical record. The story can be told only where documents exist, and documents exist most readily where institutions were forced to look. That is the final implication of the case. Not that the city was ignorant, and not that the crime was inevitable, but that the line between private disaster and public intervention was thin, inconsistent, and dependent on visibility. A usable ending is not the same as a complete account. It is the form of conclusion the law can provide, and the form of conclusion the public prefers. The case ended with executions. The conditions did not. What remains is a record of one arrangement that failed to stay invisible, and in that failure revealed how easily invisibility could be purchased, and how often it was. Bibliography. This account draws on material produced at the time of the events it describes, and on later historical work that relies on those same primary records. Because documentation of infant care and death in the late 19th century is uneven by nature, no single source is sufficient. What follows reflects the range of records that make reconstruction possible, as well as their limits. Primary sources: court records and legal proceedings. Trial transcripts and summaries from the Central Criminal Court, Old Bailey, including testimony, judicial directions, and verdicts. Depositions and committal papers where preserved. Sentencing records and execution notices. Coroner's inquests. Inquest reports relating to infant deaths connected to the case. Medical testimony submitted to coroner's courts. Verdicts recorded without identification where relevant to context. Contemporary newspapers and periodicals. National and London-based newspapers reporting on the investigation, trial, and executions. Editorial commentary on baby farming and infant mortality. Notices, advertisements, and court summaries contemporaneous with the events. Administrative records. Birth and death registrations where available. Burial records and cemetery documentation. Police and parish references cited in inquests or trial evidence. Secondary sources. Historical studies of baby farming and infant welfare. Scholarly works examining late Victorian infant mortality, informal adoption, and paid nursing. Social histories of illegitimacy, women's labor, and respectability in 19th century Britain. Legal and medical histories. Analyses of coroner practice, forensic medicine, and the regulation of drugs such as chlorodyne. Studies of Victorian criminal procedure and evidentiary standards. Notes on absence. Many infants involved in baby farming never entered stable record. Many women took deliberate steps to avoid documentation. These absences shape both the historical reality and the limits of what can be responsibly written. The bibliography therefore reflects not a complete archive, but the surviving edge of one. Where sources fall silent, that silence has been treated as evidence of condition rather than as a gap to be filled.